From Emperor's Palace in Johannesburg, South Africa's public service and union leaders gathered for 3 electrifying days of bold dialogue and strategic exchange. With education-labor disputes at the core, participants tackled the evolving terrain of employment justice through gripping case studies and visionary insights. Fresh thinking emerged, alliances were strengthened, and practical solutions took shape, responding to the demands of a shifting global economy. From dialogue to impact, witness the moments that moved South Africa's labor future.
Thank you once more for making time this morning, and welcome to those who could not join us yesterday, but who have managed to be here today. I know that other people are very good in capturing their own notes. Please pardon me for sounding like a broken record. We have to do this for the sake of those who could not be here yesterday, and some of them are the presenters. They need to be able to have an idea of what were the issues that were covered yesterday. So please bear with me if I'm sounding like a broken record. I think one of the critical issues that came across in all the presentations yesterday, starting with the JP, is the importance of Section 23 of the Constitution, the right to fair labor practices, Prof. That one cannot be overemphasized. And that right, both the employer and the employee parties must always be reminded of. I see the DG is not here. Mafu, my friend, that right is non-negotiable. Employers must always be reminded. Sometimes I get to be asked, are you still the general secretary or are you the shop steward yourself? But we're not there. But we don't also fail to remind those who are operating within the space of the ELRC that for us, this is one, and that one does not have number 2. We've got one, but that one is duplicated twice GS NATU. The second one being what? Section 28 of the Constitution, which is what? The best interest of the child. I won't talk more on that one. But if you operate within ELRC and education, you know those are the two that we live by every day. I think I'm going to forget to press this thing. I'm not techni-savvy. Penis, why is it not moving? Am I being sabotaged? Remember the draft amendments to the code are not in being used yet, so I can still initiate the processes, Therese, without exhausting that long list before we take the action. I'm joking. Your thing is failing me. Thank you. I'm not going to repeat that one, colleagues, but the principle there is that the foundation for transformation change in the workplace is to be derived from that Section 23. The employers, the judge president emphasized the importance of the employers having to be proactive, not reactive. You don't need to wait until there's a complaint and or a grievance, but you must constantly review your actions and your operations daily such that you are able to see these issues before they are escalated. But currently, what we are observing, which has been confirmed by the JP, is that the employer is more comfortable to go and defend itself, and then they will implement that, which is the outcome of the process. I think what is also key from the JP's presentation, colleagues, and I know this one, Prof, we always talk about the use of artificial intelligence. It's there. You either embrace it and move with the times, or you are left behind. I think that's what we must agree to. Because the fact that he was explaining here on how the courts have, the labor courts and the LAC have adopted the e-justice as a transformative tool, it then tells you that whilst they are using that for document management processes, Mr. Q, we need to be saying, what is it that needs to be done in terms of the court's rules? Because we have seen the judgments, Prof, on how the lawyers have been found wanting relying on artificial intelligence, citing case law that does not even exist. So artificial intelligence is there. What we want done, especially within the legal framework, is a proper regulation. You still need the human element. If you get that case law that is cited for you, go and revisit the case itself so that you satisfy yourself that there is such a judgment that exists. The judge president, again, I want to illustrate how they can best utilize the artificial intelligence. He told us that they only have 3 researchers that are servicing 20 judges. Then we complain, Semaf, why does it take so long to get the judgments? I think that question was asked by Prof, specifically making reference to the situation in the Eastern Cape. It is purely because the very nature of writing up that judgment, the judges have to do research. They are relying on research on this case law that is relevant. We have the same problem in terms of arbitration, by the way, where we have found true quality assurance processes. We find that the arbitrators, they tend to want to put reliance on judgments that are no longer sources of authority, because they would have been the updated decision on the same matter. We know how the courts, I think Judge President said the judges must be criticized but constructively. But we know how today they say this, tomorrow they say something else. But unfortunately, you go with the something else that is recent. You don't rely on that old position. So this is where then even JP and his team should be relying on artificial intelligence, because they've got shortage of researchers. To summarize, because those documents are uploaded electronically, Grok, ChatGPT, it summarizes what is the issue in dispute. What was the submission from this party, the respondent, and so forth. So I'm trying to re-emphasize the fact that even in our rules, my chairperson is not here, I think we need not to wait for any update from the CCMA, but we must be proactive and be able to guide our commissioners. What is it that we are expecting where they make use of artificial intelligence? We're not against it, we are for it, but we are saying you still have the responsibility to quality assure that which you have found from artificial intelligence, such that you don't cite cases that don't exist, or you decide the matter putting reliance on authority that has since been changed by the courts. I think the presentation from Patelia, who's always been supportive, we must appreciate him in his absence, is the importance of focusing on the relationship. Whenever there are disputes in the workplace, the managers and the employees will fight to such an extent that, notwithstanding, I think there was a question that was asked by Joyce, why did the employee opt to settle by being compensated instead of retaining the job? Now, most cases, employees decide like that, not because they've got another offer lying somewhere in their drawer, but their relations would have been strained so much, such that going back to that workplace is not going to do anything for them but frustrate them. And we know how difficult it is in our country to prove constructive dismissal. But it is there. The employer knows, is aware. And I think sometimes they abuse it because they know the courts tend to favor them because it's difficult to prove it. So that's why we then saying we're aligning ourselves with Patelia's input that we should put human first, focus more on the relations beyond the resolution of the grievance or the dispute. And then he also placed emphasis on reviving internal dispute system. And those relations, you see the sabotage that I was talking about. I didn't press anything. Those relations, colleagues, can only be maintained if we put more importance on mediation, on conciliation. And we therefore calling upon the employers, even from other sister organizations that are here, we must always try and resolve the grievances. Because if you resolve the grievances, that's where you are afforded an opportunity to build the relationship beyond what was the complaint. I think that was the gist of Patelia's submission. I think the draft code of dismissal, thank you, Teresa. I think some colleagues were taken by surprise on the proposed approach, which is likely going to pass if no submissions have been made. That provides an alternative. And if you look at those, I know there were differing views yesterday, but I'm inclined to align myself with the speakers that were saying what is intended here is to reduce the employer's power to wake up and fire a person, Prof. But you're putting these stringent requirements that they must exhaust all these processes. And that, colleagues, we must appreciate it's done in the context of the country's high unemployment rate. If you have employers who are dismissing workers willy-nilly because they are happy to just go to the CCMA, Mr. Kotoi, and pay your 1 month settlement and say, as long as the person is out of the employment, I'm happy. I'll settle. Whether they say I must pay 3 months, I'll pay the 3 months. I just want to get rid of this person. And that happens a lot, by the way, within the public service. Especially for it's not that much with our level, the educators, but you would have seen how they handle the issues of your most senior personnel within the public service. They fabricate or formulate the charges. I'm using those two words deliberately, Semaf, is by commission. They fabricate sometimes the charges just to terminate your contract, and they pay you because the money is not coming from their pocket. So I think we should pay attention to those draft amendments on the code because they will have implications in the long run. It might benefit us as the workers. It might also benefit the employers. But the principle is the fact that there's a problem of high unemployment rate in the country. Therefore, you can't allow employers to willy-nilly dismiss employees. They are now subjected to these long, tedious processes. And then in terms of the promotion disputes, I think it cannot be overemphasized that we only have 24,000 schools. So there'll always be 24,000 principals posts against 460-something thousands of educators. So that's why you would always have these complaints about the promotional post. It goes, by the way, similar to your HOT posts. The managerial posts are very few versus the workforce. So there'll always be tensions. But I think we should pay attention to what was highlighted as the root causes, as well as the effect that those disputes have amongst the workers in the workplace, where you'll have two people, they are contesting and they are saying, I should have been appointed. They're coming from the same union. That's the interesting part. Now the union has got an obligation to represent both members. So the one representative is going to come and say, no, that employee should not have been appointed. They're coming from the same union. The other one seated there saying, no, my member should have been appointed. So those are the challenges, colleagues. But I'm one of those who are advocating. Again, the DG is not here, but some of his senior managers are here. I'm one of those who are advocating that we need to relook the composition of the panels. You can't shy away from it. I think the school governing bodies must accept that, notwithstanding the powers enshrined in SASSA, for them to play an active role there, if we are to turn the situation around, the constitution and the composition of those panels need to be relooked. And by the way, let me hijack the platform and announce that the ELRC has been mandated to appoint a forensic firm to conduct investigation on the alleged selling of posts. We shall be, thank you. Once we have appointed a forensic firm, we would have them managing a toll-free number. Please encourage the teachers, the members to call that toll-free number. They have no obligation to go and present the evidence. Remember, they must just report the allegations. The forensic investigators will follow those leads. And again, we shall not leave it similar to the Volming report. We had our own Volming commission in education. So colleagues, the real issue there is that we need to have this thing addressed, and we need to look at the root causes such that we can be able to minimize the disputes. I think the important issue there that Prof kept on reminding the unions is to ensure that you become vigilant and you protect the hard-won battles. Because Prof is very concerned. I'm sure he gets sleepless nights when he sees how things are moving. That very soon, the hard-won gains are going to be lost if the unions are not vigilant. You can consult him. I know we always call him the shop steward. You know, there are there are instances where some parties to disputes will always say, no, we prefer Professor van der Walt, because he's not that it does not apply the law, but he's known to be a shop steward. Again, I'm not able to move my slides. I need to move with speed. Yeah. Mr. Israel Stam, you don't know how many times I tried to practice pronouncing his name. And maybe that is not here, but I didn't butcher it. Again, what was critical from his input was the fact that the employers must try and avoid leaning towards legal technicalities. And he reminded us that the spirit and the objective of the LRA is that labor disputes must be resolved without bringing in those legal processes that under normal circumstances should be reserved for courts. But from his research, he's saying that the employers need to be from time to time reminded to try and shy away from that. And then he said there's a need for the employers to balance strict compliance. Or he said there's a tightrope where the employer is faced with the challenge of having to balance strict compliance with productivity, but on the other side, there are these obligations that I have outlined in the employment regulations. So he said there's an importance to ensure that they walk that tightrope such that they strike a balance. So it's a balancing act. And then Mr. Q, the very last one, he dealt with unlawful contracts and the constitutional supremacy. I think the examples, colleagues, the case law that he was citing, I was having an informal chat with him and also other participants. What is coming up very sharply is the inconsistency of the courts on how they are deciding matters where the respondent is an organ of state versus the private employer. And those decisions create the impression that the LRA has been designed to deal with matters differently when it is the private employer versus the state, the organ of state. And I think we were also saying with the colleagues, we do understand why would that be the case in some instances without justifying it. I've got a couple of examples. I want to start off with the one that is very fresh in my mind. There's a requirement, Prof, that when employees have engaged in a strike action, the deductions must be effected. And that requirement comes from the Northwest Provincial Legislature judgment versus Nehau. The court decided that if there's a strike action, the deductions must be effected the same month as the strike. How possible is that in the public service? One, you are dealing with too many employees. In education on its own, I told you are looking at about 444,000 educators. You still need to gather the data Letitia, from all your managers, the HR in each department and so forth, you then have PESAL standard operating procedures that any changes on the salary must be captured on PESAL by a specific date. You with me? Now, it's practically not possible to comply with that in the public service. In the private sector, it's possible, because there they are not having these rigid regulations that are there in the public service. Now, you can't do that. Now, if you miss, Jones was reminding me that if you miss that deduction in the month that a person would have embarked on a strike action in, then that becomes a debt. What is the requirement when there's a debt? You offer the employee an opportunity to make payment arrangements. So it's a very complex situation. The other example, I think it was mentioned yesterday, is the existence of your deeming provisions within the public service. You don't have that in the private sector. But it's something that must be managed, it's something that the courts are deciding, and there's confusion. What is also of concern to us who operate in the spaces that we're in, some of the court judgments, not intentional, unintentionally so, they can be viewed to be undermining the spirit of collective bargaining. I was talking to my friend from the DPSA. I said, I'm going to put you under spotlight and make an example of the Constitutional Court's decision on the implementation of Resolution 1 of 2018. There's a collective agreement. The law presides that the collective agreement supersedes the legislation. The court decides that, no, the employer had not complied with its regulations. Who is this employer? The state. The employer is not complied. The regulations are there and they are valid, and they have to be complied with. Now you need to balance that with the force and effect of a collective agreement. We had a similar case, Prof, within the ELRC. Simone is sitting at the back. I'm not putting anyone under spot. I told DPSA that I'm not putting them under spot. We had a collective agreement on the remuneration of markers. Similar case there. The issue was funding, similar to the Resolution 1 of 2018. The state withdraws the collective agreement after having signed it at ELRC. What does the court do? They decide in favor of the state. Is that not undermining collective bargaining? Is it not high time that as the public service, we put up a strong case that you either have two separate dispensations, that which is applicable in the public service, which, by the way, it used to be like that historical, until they promulgated the LRA, which was meant or intended to cover everyone without any differentiation. But the decisions taken by the courts are pointing to that. We either have those two separate dispensations, or within the LRA, you've got one applicable to the public service, appreciating these challenges. And again, colleagues, we are affected as well as the bargaining councils. I was making an example earlier on. I'm finishing program direct before you come my way. We were saying we're required by the CCMA to submit on our efficiency rates. And those efficiency rates include the number of settlements, Prof, as well as how long does it take for us to conclude our matters. We would have one case that will take 4 years. We're fully cognizant of the fact that it does not go in accordance with the spirit and the objective of the LRA, which talks to resolving labor disputes within the shortest space of time. But what is causing that delay? The mandates that must be obtained. Within the public service, you've got the bureaucracy is just too long. It's not the same as in the private sector, where you pick up the phone, you speak to the MD of the company or the HR director and say, look, I'm in this process and we want to settle. This is what is on the table. Then you are given a mandate over the phone. You can never get that in the public service. This one must generate a submission. It goes to number 2, number 3. By the time it gets to the one who's authorized to sign off and say, yes, we agree or we don't agree, you would have lost so many times. Thank you, colleagues. That's my story and I end it here. Thank you for listening. Bye-bye.
Thank you so very much for that comprehensive overview, GS. Ladies and gentlemen, so this also puts us straight into the second session for the day. And I'd like to call upon our next speaker and presenter, Mr. Lux Kubjana, who's Senior Lecturer at UNISA, who's going to talk to us about understanding the law on sexual harassment in the workplace. Round of applause.
Yeah, as they indicated, my name is Lux Kubjana. Yeah, I'm going to talk to you about the sexual harassment. And I believe that all of you can agree with me that sexual harassment has become is topical, and not that we like it, but it's there. We experience it every day, and it is being experienced by everyone. However, the difference is the extent. It affects both male, it affects both males and females. The only difference is the extent. So women are more prone to experience sexual harassment. So, and it is a serious problem which has got serious effect as well. So it's not only a problem, but it has got serious problems. And the problems or the effect of it is that it doesn't only affect only the victim. It also affects the employer. And again, even the public. How so? For victim, it's obvious. Obviously, it affects the victim's dignity. It takes away the victim's sexual autonomy, because in a way you are being forced to engage in some of the things that naturally you want a wish or you want to engage in. But it also destroy families, because if, as a receiver, as a victim, you happen to experience such, so you will no longer see the need to go to work. And then if you don't go to work, you remain home, obviously there won't be salary that will be coming into your house, because as you know, we are salaried people, and our law is very clear. You render a service, and then you get paid for the service that you have rendered. So now, you are in between. You have to go to work and work for your family and meet your needs. But the very same work is supposed to be a conducive environment for you to can do such. But unfortunately, the situation as it is today, it doesn't allow that. Yeah, the situation, the work environment, it doesn't allow that. But colleagues, as I'll go, we'll get to the point that I want to traverse on. But we cannot take away the initiatives already taken by our government. I will say our legislature. So our government, has showed a commitment, and there is a will as well. We've seen through a number of laws that were promulgated or created to try and deal with problems such as the problem at hand. But me and we can agree that despite that, we've got a number of laws. We can get to that just to show you how many laws we have which are dealing with sexual harassment, whether directly or indirectly. But the most important thing is that, there is no way you will be able to deal with anything. You can't deal with anything if you don't know what is that anything. Firstly, you need to know that particular problem. What is it actually that is troubling me? So once you begin to establish that, now you know the problem. My problem is this one. So it becomes easy for you, I mean, to can deal with the problem because now you know it. But one of the challenges that colleagues, I mean, as I was going through sexual harassment cases, sexual harassment legislations, is the problem that, I mean, we are at a point where we, in my view, I know very well that, I mean, you may have different views, and I respect that. In my view, the problem is that we don't know what is sexual harassment. I don't know as well. Because if you go out there and read what is sexual harassment, yeah, it will tell you. You just say, I mean, it's unwanted conduct of sexual nature. You see, unwanted conduct of sexual, or unwelcome conduct of sexual nature. But I'm going to show you that, I mean, certain conducts, which when you see them, I mean, I would say certain conducts, which when you look at them generally, or in a reasonable person sense or view, they may turn out, when you look at them, they look innocent. When you look at them, say, no, this one, no. Maybe, I'll give you an example here. Let's say, I have a colleague, and you do it every day. You have a colleague. Some of the colleagues, I mean, in the morning, you greet each other, hugger. Then it's fine. It's normal for you guys. So, but I can tell you that, I mean, we've got cases such as that where they're dealing with hugs, and some of the cases, I mean, when you look at them, I mean, you'll be like, no. And especially if, I mean, you know the relationship between I would say the litigants, the people in question. So, because you know them as these people who are always, I mean, happy and greeting each other. And of course, there are cases where, I mean, when you look at the behavior, despite the relationship that I've just alluded to, then you realize that, no, here, I mean, somehow the doer, I would say the doer, yes, the doer may have crossed the line. So they are clear, even if you can call, I mean, somebody, a learned person, I will be able to tell you that, no, here, this is what I'm seeing. But others, they are hidden because they are so sophisticated. Every day we read news, we read cases, you find that there are such type of those cases. I'm coming now to the regulation of it. I don't know whether I'm ahead of my slides. Yeah, the regulation, I'm on it. So we've got legislations that are dealing directly or indirectly with sexual harassment. International law here, obviously international law is there to guide us. To show, it's not necessarily, I mean, going into the nitty-gritties. What it says to us is that countries, for a good standards, please consider doing something of this nature. And then I can tell you, I'm proud of South Africa. South Africa, I mean, was ahead of this convention. Already when this convention was actually, I mean, developed, South Africa already had, was some step ahead in terms of dealing with sexual harassment issue. And then amongst the laws that regulate sexual harassment, the colleagues, I mean, you can see, I've highlighted them. They deal with this aspect, whether directly or indirectly. You have Section 23 of the Constitution. It's very clear to us. It says to us, everyone has got the right to fair labor practice, which means that when we are in a workspace environment, we are expected to be in a place where, I mean, environment is good for us. And then this concept, fair labor practice, it is not explained or defined anywhere. You can't find it. So, I mean, it is housed in the Constitution. If you go through the Constitution from page 1 to the last page, it is not defined anywhere. So, but at least, I mean, we've got our courts, they've tried to give it at least, I mean, a sense. At least, I mean, now we know when we speak about this concept, what is it that we're talking about? I'll refer to the case of NUMSA versus, it was Nehau versus University of Cape Town. Sorry, colleagues, some of the cases, I'll just say them, from the top of my head. Obviously, those that I remember. When I sent slides, I also sent a catalog of cases, which, I thought maybe, they were going to print it out. That is how far I'm backward in terms of, because nowadays, it's technology, So I want us to use those cases. So, but in this particular case, how an attempt was made to try and give the right of fair labor practice a content. In terms of that particular case, the right of fair labor practice doesn't only talks to the rights of the employees. It also talks to the right of the employer. So, in other words, when you look at that particular section, you need to know that, it is wide. It covers both the interests of the employer and the employee. But then you can also, in that particular very same section, you can also, understand that the right of the employee in that particular section, obviously it will be that the employee must be in an environment that is conducive, safe, and worker-friendly. But if you are going to have sexual harassment at workplace, I don't think, it is talking to that particular section. Next to that particular section, we have got section 24. That one is very clear. It says everyone has got the right not to be subjected to an environment that is harmful to that particular person's health or well-being. Obviously, I've just said, if there is sexual harassment at your workplace environment, then it means, you are right in terms of section 23 and section 24, it is being violated. And then I've also gone as far as going to section 28 of the Constitution, where all of us know that I was trying to put it next to the theme, because we are here in the basic education where we find our kids. So that particular section, it talks to the right of children. Yeah, children needs to be in an environment that is safe and conducive for them, to can learn as they grow. And we have section 39. This one, obviously, it gives us permission to can, when we interpret the law, to can at least, actually it gives us a directive to say when we are interpreting, applying, and obviously developing our own laws, we need to be in line with the international law. The international law, obviously, I show you the convention there. So it means, our law must be as much close to the ideals of that convention as possible. The question me and you we should be asking ourselves now is, obviously we know our laws. Are we in par, close, or are we still trying to get there? So that is for you, colleagues, to can judge. If you remember very well, when I started here, I said our constitution, our government has done, has shown a commitment and a will to want to deal with these issues. And colleagues, thus far I've showed you a number of laws, including the Employment Equity Act, Section 54. It's the one that brought about the code that we're having. And then we've got OHSA. All of us know what OHS does. It's about safety at workplace, and the protection against harassment. Our act there, is trying to deal with that particular issue. So I've counted about 7 or 6 or 8 legislations and the code. So, but still we have the problem of sexual harassment. So we should be asking ourselves, we have got the comprehensive law. It is there. You are protected by the Constitution, the common law. There are many cases, court pronouncements. There are legislation, there is code, there is international law. But why are we still having this problem of sexual harassment? And it is there. I checked the stats before I come here, colleagues. And stats do not lie. Stats are saying in the basic education, stats are saying, cases in the education sector, the basic one, they are saying cases of sexual harassment as of today, there is an increment of 111, that is 101 cases, despite the fact that we've got that particular law. I also checked the national statistics, colleagues. National statistics are also saying in the first quarter of 2025, the cases of sexual harassment, they are going up. We are sitting, we can't say we are sitting, because I checked the first quarter. First quarter, in my understanding, will be from January to March. They say we've got 13,000 plus cases of sexual harassment. You can imagine how the dispute resolutions that we have, are the type of the job that they have to deal with. And in those cases, obviously, I want to believe that it will mainly be determined on the basis of what is this? Yeah, it will be out of those institutions, be it the ELRC, CCMA, or the court. They will determine whether it is sexual harassment or it's on sexual. As to what the criteria is, I can tell you that is where we have a problem. That is why we have 13,000 cases. That is where we have 11,000 cases going up. And again, that is where we have so many cases of sexual harassment, which if you go through each and every one, sometimes I'll feel like I'm crazy. Yeah. I'll read 1-2 cases and I'll say, no, but then I've read these cases, but then even now, I'm still not able to get what actually is this sexual harassment. Because today, you get this particular case. They will tell you about these people who were hugging and as usual, they normally hug and handshake and all those kind of things. They travel together, perhaps. They say, no. One of them, will come out to say, I was sexually abused. And then the facts will be that, obviously, I was hugged. Then, be it a CCMA, a court, or ELRC, they will say, no, there was a case, the case of sexual harassment was not established, it was not found. These people were just hugging, and hugging, it's normal. People normally hug. But you'll find the same case, now it's being decided elsewhere. For the argument's sake, let's say the first one was decided by the ELRC. You'll find the other being decided by the CCMA. When you check the facts, they are more or less the same. There was a hug. These people, they know each other. Like it's normal. Then that one will say, no. This one is a sexual harassment. We have got 2 cases. When you check facts, but these facts, obviously, they can't be the same as in. But when you check, substantially, these cases, are the same. These people know each other and all of that. But the other one is found to be sexually harassing, and the other one is not sexually harassing. So you ask yourself, actually, yeah, we have got the will, we are committed, we don't want this sexual harassment, but the only problem that I'm seeing is that we need to find a definition. We need to find a definition where we're going to, at least as a starting point, when we confronted with cases like this, we're able to say, no, let's go to the guiding principle. This is the definition. What does the definition say? Because the one that we have in now is wider. And actually, it gives whoever will be presiding on cases such as this, what is this? A carte blanche, just to decide. It will depend on the mood of the person on that particular day. That is what that's my feeling. And in the process, people are being hurt. In the process, people are being destroyed. People, they're depressed. People are resigning, and their family are being destroyed because of the same thing. We've done a lot in terms of making legislation and all those kind of. Can't we just have, maybe a task team of experts, big people, professor level, and sit down and try to find just a definition that will work in all cases. Because if we don't have a definition, we have got and as a result of lack of definition, we have the kind of the cases that we are having, colleagues. It also, gives us, that's the end product. It gives us an inconsistent jurisprudence on this problem. And then for as long as, the jurisprudence is inconsistent, so we are going to have this situation. Those who committed sexual harassment and then as in objectively so, they will get away with it because of the inconsistencies. Those who didn't do it, but they just happen to have done something that relates to that, they will find themselves, and someone yesterday, if not two people, as they were presenting, they spoke about social justice as one of the the ideals which our labor law is trying to, our labor laws, especially primary labor laws. If you go through the preamble or the purpose of our primary labor laws, or Employment Equity Act, Labor Relations Act, basically, it will tell you that one of the things that seeks to achieve is social justice. And social justice, obviously, it goes both ways. It cannot be that we say, there is justice if for every case that is being reported, then somebody is found guilty, and then he goes home, and it's no longer working, kids suffer, and everyone else around it. It can't be, it's not something which we're wishing. We wish, where we say social justice, let it be that this person indeed has committed that particular offense. Indeed, colleagues, there is clear cases of sexual harassment, which me and you, we can detect from a very much long distance. But there is also sophisticated ones. There are sophisticated ones, colleagues, which it is not easy. It is not easy for us to detect. And before I get to those cases, colleagues, I just want to go through one of the observations made by the court in Bandar versus the Kok. And they were raising the same issue. They were saying, I'm reading it out, I'm opening up the quote. It says, how does one then go about objectively determining whether the kind of conduct as set out in clause 5 of the code is unwelcome? In my view, that is the quote. In my view, the first question that has to be asked is whether the conduct was ever complained about by the employee. This can be done by the perpetrator being informed that the employee considered the conduct to be unwelcome, and the perpetrator then being called on to cease the conduct, which is what our current code, as when I read it, I understand it to be talking the same thing. But it doesn't end there. It says, it gives a space for certain instances where the receiver doesn't necessarily have to, the doer doesn't necessarily have to expect the receiver to push back the whatever the advances the doer is advancing towards her or him. Those it is said the doer, there are certain contacts with the doer is expected, reasonably so, to have known that this type of conducts they cannot be acceptable wherever they they will not be acceptable or welcomed by the receiver. But the same code, it also said there will be sexual harassment. In this case, I mean, it says sexual harassment can be committed expressly or impliedly. That is, it is this, the implicit one, that is problematic, colleagues, because that one is going to go to, it goes back to what I said earlier to say, the implicit one, now, I mean, it's going to introduce that which, I mean, we had, the code was trying to take out from the code, which is the subjective view of what amounts to sexual harassment. Because the moment that we say, I mean, it is implicit, so it means, I mean, it's hidden somehow, and it only needs a certain type of people to come and pull it out. And it may be problematic in the sense, in that sense, because that which when it comes in that way, it gives that vibe that it is not clear, so it needs certain type of, I don't know, maybe IQ to can take it. And unless you know that, I mean, we are not the same in terms of our psychological makeup. That which, I mean, you can see as, I'm speaking about this one, the implicit one, something which, I mean, you can see as clearly sexual harassment. Someone may not necessarily see it as such. This has, this type of approach, I mean, had already, before the coming into being of the upgraded code, has already received criticisms from the likes of your Detroit. Yeah, Detroit, I'm quoting him or her, sorry. Detroit et al., they are saying, they argue that the problem with the using a subjective approach is that forms of conduct that an overly sensitive person will deem to be harassment could then be included for sanction. So, exactly the point that I've just mentioned. We are different in terms of our make, how we respond to things and all of that. There are overly sensitive people here. If you hug that particular person, I mean, hey, you've done something, no, you have encroached, like you actually invaded that person's space, and therefore you'll have to answer for that. And then, again, Brazy observes that, I mean, sexual harassment denotes more than just an act by which a perpetrator seeks some sexual or similar gratification from an unwilling victim. So the more we speak about sexual harassment, the more you read about it, that is more the problems we get. And I strongly believe that all these problems, they can be behind us if all of us can just sit down and try to find a working definition. Because once we have a definition, and it is very easy. I'll give you an example of criminal law prescriptions. If they say somebody has killed somebody, someone else, you know that they say it's murder. You know where to start. There is a definition. That definition, I mean, it gets process. It makes even the disposing of the case, I mean, easy, process, faster, and all of those kind of things. But then if you don't have that, and then you are just looking at that open-ended, I'm reluctant to call it a definition, I'm just saying description. So in my view, it's one amongst the problems, colleagues. let me just go through a few of the cases that I actually prepared for this event. There is a case of Amatole District Municipality versus CCME. Yeah, in that particular case was decided in 2023. That is after the code, the new code, 2022. In this particular case, what the accused did, they say the accused would call the complainant into the office and colleagues, I'm getting a message that my time is up, but I have prepared cases which obviously the organizers are here. I hope that those cases they'll be able to share them with you colleagues. And then in the interest of time, colleagues, I'll say thank you very much for listening to me, but then there are other things. I'm not just here appearing in an armchair approach, colleagues, but what I'm saying those are what we can perhaps try to do. Obviously, the basic education, they are doing something about it. They are not prevaricating. Should you be found to have committed sexual harassment, and then they show you the door. And then in China, colleagues, they can sue the person himself. It's not only the issue of an employer. They can sue you as the doer. So I think we can go the same way. Although obviously I know we can come across people who will say that will be double jeopardy. Thank you very much, colleagues, for listening to me.
Thank you very much for that presentation, Mr. Lux Gupjana, and he's the senior lecturer at UNISA. Now, ladies and gentlemen, we'll now be moving to our next speaker for the morning, and that will be Professor Alberton from the University of the Witwatersrand on inequality in the South African Constitution. Round of applause.
Good morning. It's a real pleasure to be here. I'm sorry, I'm going to take you out of your comfort zone. I'm a constitutional lawyer. I'm not a labor lawyer. But I am going to be talking about how the Constitution frames equality and touching on some issues that will be pertinent to you. But in those of us who were around in 1994, you will remember there was considerable hope and optimism that, armed with a very highly aspirational constitution, the South African government would go about addressing the very deep and systemic inequalities in our society. 30 years later, of course, we know not much has changed, and possibly it's gotten worse. So in trying to understand the persistence of that gap, some people, well, some public lawyers and some politicians, have turned their gaze upon the Constitution and said, well, could it be the Constitution itself that prevents, constrains, or empowers government, courts, and the people to address the deep inequalities in our society? That question is both locally and globally relevant. In local terms, the Constitution's apparent failure to generate meaningful change is a risk to its legitimacy, but it's also led to the political and academic dismissal of the Constitution, its rainbowism, its Western character, its meaningless triumphalism as the best constitution in the world, and so on, and so on. We've witnessed calls for its amendment in whole or in part, and we all know about the EFF's persistent calls to renew and redo Section 25. And we know the MK Party has called for its complete rehaul. And in academia, decolonial scholars such as Sibanda Madlungozi and Madeira see the Constitution as a source of false hope, of betrayal, coming from a weak political settlement, and so tainted by liberal democracy and Western norms that the only way forward is to start again and engage in some kind of radical innovation. In global terms, we see the persistence of liberal democracy and neoliberalism, neoliberal capitalism has actually well, the question is, has it led to the rise of inequalities across the world? So if neoliberal capitalism as an economic system has led to deepening inequalities, and I don't think there's any doubt on that, does the political system that goes along with it, liberal democracy, bills of rights, etc., independent judiciaries, is it similarly implicated? Is the relationship between the growth in neoliberalism and inequality and the growth in the use of the Bill of Rights and human rights, is that merely a correlation? Are human rights just hapless companions, if you like, to deepening inequality? Or is there some kind of causation? Now, we also look across the world and we see that in times of economic distress, support for liberal values and democracy has declined. And we've also seen, I mean, most recently in America, but also across the world, we've seen the emergence of populist leaders, authoritarian leaders, on the support of a wave of support, and those people have begun to dismantle and neutralize judiciaries, reverse social inclusion, dismantle respect for the rule of law. So these are big questions that require careful debate, and I don't think we should turn away from them, but they're way beyond the scope of this particular address. I want to have a slightly narrower focus, and I want to engage the debate through our Constitution and how I see its role, and then what our Constitution has and can do about inequality in our society. So I want to briefly recap what a constitution is, take you back to Constitutional Law 101 for just 5 minutes. And then I want to look at what our Constitution says about equality, what kind of idea of equality is present in our Constitution, and then I want to look at some of the jurisprudence just to show you what's been possible in dealing with the various social and economic inequalities in our society. So, now I must move on. So let's start with what is a constitution. So we all know that a constitution is a foundational law that establishes the power and the structures of the state, the rules and principles that organize power and decision-making, identify the rights and duties that govern the relationship between the state and its people. So it does all those important, fairly technical public law things. It establishes the state. But over and above that, constitutions express the character of the nation, they define its people, and they set out its collective values and aspirations. So constitutions are very often judged in terms of those political characteristics, right? Does it abide by the rule of law? Does the country have an independent judiciary? Is there a free press? Is there separation of judicial, executive, and executive power? That's an important measure of a constitution. And in South Africa, of course, it's an important measure. And we know that our liberal democratic features such as independent courts and accountability have been really important tools in the struggle against corruption and malfeasance in the state. But they also exist alongside much more participatory elements. So insofar as corruption eats the resources of the state to address poverty and inequality, the role of the Constitution in holding state power to account is all about protecting those resources and institutions. I think it's played a powerfully important there. Without our Constitution and without our strong institutions, we would not have been able to do what we've been able to do in relation to state capture and corruption. However, constitutions are increasingly judged in terms of substantive social and economic ends. The South African Constitution is an explicitly aspirational and transformative document. You'll know that, right? It's committed to freedom, equality, dignity, human rights, and social justice, which I know you spoke about yesterday. Its preamble self-consciously commits us to establish a society based on social values, democratic values, social justice, and fundamental human rights. We need to improve the quality of everyone. We have a robust and a redistributive equality right, which I want to talk about a little more. We also have positive socioeconomic rights, which I won't talk about. And in many ways, we judge the Constitution by the extent to which those rights are made real in the lives of people. So the idea that the Constitution itself can ground meaningful social and economic change. That's a tool in the hands of government and civil society to begin to bring about a better society, is captured in the idea of transformative constitutionalism that many of you will be familiar with, that was introduced by an American scholar in 1998 to tell us that we could actually engage in wide-scale social transformation under the discipline of our Constitution, because our Constitution was so expansive and committed to a long-term project of constitutional enactment, interpretation, and enforcement to transform our society. And there's been a lot of debate amongst legal academics about transformative constitutionalism. A lot of that is boring for the purposes of this meeting. It focuses a lot on jurisprudence. How transformative is jurisprudence? How can we really trust judges to bring about really kind of progressive egalitarian change? And there's been a lot of criticism of judges. But it's important that transformation under the Constitution is not just a project of judges and courts. It's also a political project. So it engages courts and parliament, legal interpretation, and most importantly, democratic participatory politics. So although judges are tasked with enforcing the Constitution, in fact, courts address a minority of policy and legislative issues that matter to us. And the challenge of transforming our society lies much more within the purview of Parliament, the executive, and the administration, rather than the courts. And ultimately, of course, it's the social and economic policy choices of government and whether they are implemented through legislation, programs, and administrative action that really determines the nature of social change. So in that sense, the 1996 Constitution is neither miracle, nor false hope, nor betrayal. It's just a product of an anti-colonial and anti-apartheid struggle and a political settlement that was made in very particular global and local conditions in the early 1990s after the fall of socialism, the fall of the Berlin Wall, and the rise of liberal democracy. So while it's by no means perfect, I do think it's a positive framework that enables but does not guarantee transformative change and not is in itself the cause of ongoing social and economic inequalities. Rather, one can see it as a kind of scaffolding that we use to build our society through political and legal action, not only by the state, but by civil society. And obviously one includes unions and social justice organizations within that. So I see the Constitution as a kind of contested, normative and practical space that requires all of us to constantly articulate and defend its vision and to make it meaningful at all levels of social and economic life. So what I want to do quite quickly, I hope, is really to define the meaning of equality, to talk a little bit about that debate between formal and substantive equality. It's in the news again. I do think it's worth rehearsing from time to time. To talk a little bit then about how Section 9.2 of the Constitution has framed the court's decisions, and then a little bit about Section 9.3 and what that's meant for law reform and litigation in South Africa towards social equality. So we know that the nature of equality is really often said to be divided between formal and substantive equality. In post-apartheid South Africa, both meanings have traction in law and in politics. So formal equality at its simplest level basically says that all human beings are morally equal. No one can disagree with that. But they go on to say that requires that we should always be treated in the same way and that we need to eradicate what are seen to be irrational and arbitrary differentiations, or what they would call discrimination, on the basis of race, sex, gender, and so on. So formal equality goes alongside with a very strong emphasis on individual freedom, civil and political rights rather than social and economic rights, and quite narrow anti-discrimination measures, which are seen to be a formal protection against racial, gender, and other forms of differentiation that prevent advancement on merit. Significantly, because it requires consistent treatment, because it sees differentiation on the basis of race and gender as almost always irrational or arbitrary, it has very limited tolerance of positive measures. Those are generally seen to be reverse discrimination. That doesn't mean to say that positive measures or affirmative action are not always outlawed, but they tend to be limited to forms of corrective action where there's a clear link between actual disadvantage and the person being promoted, or where there's a clear link between actual intentional discrimination by the actor or the employee and the call for affirmative action. So generally, we've seen formal equality. Well, most recently, of course, we've seen it in Trumpian America, and lots of travelings between the two. But generally, it's been the kind of equality that has been put forward in the 1990s by white political parties, the National Party and the Democratic Party. Today, in different forms and in different ways, by the Democratic Alliance, Race Relations, Solidarity, AfriForum, who would advocate for a more, where they would argue that non-racialism is more about a kind of formal colorblind equality, where racial differentiation and the use of race should be kept to a minimum. And tend to be forms of discrimination against white people and minorities. So we know that ideas of formal equality continue to have political traction, but generally we also know that they've not really found a place in state policy and nor within the jurisprudence of the Constitutional Court, which has tended to embrace a much more generous interpretation of what we would call substantive equality, seen as the kind of equality that aims to address historic and collective patterns of unequal social and economic power, disadvantage, and inequality. It's also widely recognized that that's the form of equality that is endorsed in our Constitution, which recognizes it as a right and as a value. So if, whether you're in the Labour Court or the Constitutional Court, you would certainly hope that that court is following the tenets of substantive equality. Section 9 is the primary legal mechanism for substantive equality, and it challenges irrational state classifications under Section 9.1 and unfair discrimination under Section 9.3. And of course, Section 9.2 provides permission for and a defense of positive measures that are targeted at disadvantaged groups. The Section 9 right is also operationalized via legislation, so you'll be particularly familiar with the Employment Equity Act, which addresses, as you know, workplace discrimination and affirmative action. But the 2000 Promotion of Equality and Prevention of Unfair Discrimination Act is a wonderful, I think, with great potential and highly underutilized piece of legislation, except on hate speech, that really addresses discrimination across the public and the private sectors. And I really think it should be used far more. To some extent, it applies to the workplace to the extent that it's not dealing with employer-employee relationships. So, for example, sexual harassment between co-workers would fall under the Equality Act if it's not going to be a vicarious liability issue. So when we talk about substantive equality, we expect it to have, as I said, particular tenets. So it doesn't just focus on sort of abstract rights-bearing individuals. It's concerned with the fact that there are historical and contemporary patterns of disadvantage and discrimination in certain groups. You know those groups are defined by well-known characteristics: race, gender, disability, sexuality, citizenship, social origin, marital status, language, religion, culture. All of those are grounds of discrimination. We also know that the groups that can be brought before, that can come before the court with a claim of discrimination can be intersectional, right? So a group of black queer women, or black poor woman constituted by 2 or more grounds. It's very useful to use intersectionality because it casts a spotlight on the actual conditions of the actual group that's come before the court. The idea of substantive equality is group-based. It looks at relationships between groups, and it's asymmetrical, right? So the disadvantage is going to tie itself to one side of the equation more than the other, black rather than white, women rather than men, gay people rather than straight people. So it's concerned with social groups, not economic groups, right? So we know the courts are not particularly comfortable dealing with sort of class and poverty issues, much more comfortable looking at social groups defined by race or gender or sexuality. But because inequality clusters in certain groups, it means that even if you're addressing what appears to be a social inequality in relation to women, it'll often have distributive consequences because women are also likely to be poorer than men. So the problems are not just problems of social recognition, the problems are often distributive problems of class and poverty. So while formal equality equates differential treatment on the basis of sex and gender with discrimination, right? So they very much overlap. Substantive equality doesn't worry about that particularly. Substantive equality is worried about the harmful impact of discrimination. That means that actually you might want to differentiate in order to promote equality, right? And we know that the idea of substantive equality often places positive measures at its center, that in order, for example, to help women in the workplace, women need rights concerning maternity benefits, maternity pay, maternity leave, sexual harassment. Now, obviously, some of those also apply to men because things like parental leave are really important, and men too can be harassed, not as often as women, but it's certainly possible. But certainly, you would in those instances differentiate often on the basis of sex. In affirmative action, you might differentiate on the basis of race or sex and race. So substantive equality is a very different animal to formal equality. And in a way, once you choose one or the other, you kind of are walking down parallel pathways. And part of what I think would be important is that we need to find ways of meeting across those parallel pathways, but I want to talk a little bit more about that later. So I want to move then to section 9.2, which is at the center, no, section 9.3 is probably the center of section 9. Section 9.2 is the second center. But a redistributive idea of equality, the kind of redress for decades, if not centuries, of exclusion, dispossession, marginalization. So that redistributive idea was at the heart of political struggle and really lies at the heart of our Constitution. Our ideal of equality is aimed at overcoming not only individual discrimination, but importantly, the structural inequalities of race and gender in our society. So section 9.2 sets that out clearly, right? To promote the achievement of equality, legislative and other measures designed to protect or advance persons or categories of persons disadvantaged by unfair discrimination may be taken. This section enables but does not mandate positive measures and redistribution as part of equality, does not dictate policy choices. It doesn't say what economic choice you must make, what particular positive measure you would take, but it does subject those to a degree of constitutional control, right? Section 9.2 finds purchase in legislative form in the Employment Equity Act and in Chapter 5 of the Equality Act, which is a wonderful chapter on positive measures across society, but it has not yet been promulgated, so you're not held liable in terms of that chapter. It's a pity, I think. It's an endless process of amendment in the Department of Justice, and we're not seeing any light at the end of that tunnel. So, and interestingly, while I think there have been quite a lot of challenges in labor law, there have been very few challenges to positive measures that have reached the courts under section 9.2. Right? No, there's a handful of cases, really. And I want to just quickly just go over those, just so you can see at a constitutional level what's going on. Because the constitutional level does not always talk to the labor law level, which I think is a pity, but it's just how it's been. So at a normative level in 2004, the Constitutional Court embraced the idea of the transformation of the economy in Bartow Star, and it accepted that it would affect privileged groups and might even affect economic stability, but it was a kind of constitutional imperative. And in the same year, in the famous case of Minister of Finance versus Van Heerden, we know that Deputy Chief Justice Masaneki was very kind of articulate and lyrical about the importance of restitutionary equality, and very clear that positive measures were subject to constitutional control, and developed a test in terms of Section 9.2. It found 3 criteria that needed to be complied with. So if you came to court on the basis that you had been discriminated against because affirmative action had been used wrongly against you, the employer, if the Constitution applied, could then raise a Section 9.2 defense, and you would not go into a discussion of fairness. You would look at the defense. Does the measure target a person or group disadvantaged by unfair discrimination? Is it designed to protect or advance? Does it promote equality? The focus there is not on the dignity of the individual, but rather on remedying collective and structural disadvantage. So it's a different weighting to a discrimination inquiry. A discrimination inquiry will focus on the impact of the individual bringing the claim of the discrimination. As soon as you raise an affirmative action defense, then the idea of remedying collective disadvantage comes into the play, and the courts then have to balance the two against each other. Rights versus interest, means versus ends, with underlying values, and is entitled to place the thumb on the scale of remedying collective disadvantage. So that's an important point, but the courts didn't follow it for 10 years. So generally, courts continued to proceed with affirmative action cases as unfair discrimination until they were brought to sort of up to say, and in the case of Barnard's, the Barnard said, no, actually, you have to follow the Van Heerden test. And then I'm not going to go into the other cases, but really all the other cases, I call them the equality wars. They continue to be a war between the lawyers for the trade unions trying to argue that affirmative action is always wrong and oversees individual dignity, and the court's trying to say, no, actually it's important because remedying structural, collective structural disadvantage is important for the courts. And I don't have time to go into the detail, but I can't help feeling we've missed something important in those cases, that had we gone into the cases agreeing on the need for positive measures and trying to determine an appropriate reach, the jurisprudence might have gone a little bit further than it did. In the last, and I have about 8 minutes, I just want to talk about Section 9.3. Section 9.3 is the most litigated right in the Constitutional Court. About 50 cases, 45 to 50 cases, half of those on gender. So it's been an incredibly important right, but it's been important mainly for fixing up the legislative framework that this government has inherited. So it's being used mainly by groups defined by sexual orientation, citizenship, and gender to go to court to say, these laws discriminate against me, exclude me, do not give me equal rights. And it's been incredibly powerful and successful in that way, right? So I won't go into the niceties of the Harkson versus Lane test. Anyone can go and read that. It's evolved over time. The court uses it in 10,000 different ways, depending on the outcome that they want in a particular case. I think one of the best articulations of the case is probably Margie Victor in the Mahlangu case. But early on, we all know LGB, and I say LGB on purpose because it was just lesbian, gay, and bisexual. There was no T and I and Q in those cases, right? It was gay and lesbian individuals and couples coming to claim rights. So the first case, we know, decriminalized same-sex sexual conduct, focusing on the individual effects of stigma, stereotype, and prejudice, and the impairment of dignity of gay men. So, and there's a lovely paragraph from Albie Sachs where he talks about a love that was illicit has now become permissible, and how that affects people's dignity and ability to live their lives. And we know that in a very carefully thought through litigation strategy by the gay and lesbians associations, those cases moved through extending rights to same-sex couples and relationships in the workplace and in other ways, finally leading to marriage in the Fourie case. So that was a really important category of about 8 or 9 cases that really extended rights to people who would not have got them through Parliament. And everyone knew that. And everyone knew how long the Civil Union Act did take. The Parliament had to pass it because the Constitutional Court in Fourie had said you must pass it, and that shows the important relationship between litigation and law reform, right? But for the Constitutional Court, I'm not sure there would be LGP rights to the same extent today that we have. A second group are, and also a very popular group, non-citizens, right? Not as many cases in the Constitutional Court, maybe 4 or 5. The cases are very clear that permanent residents are no different to citizens, right? So if you discriminate against a permanent resident, that's likely to be unfair discrimination. The famous case of Khoza versus Minister of Social Development, which extended social grants to permanent residents. The well-known case of Labi Odom, maybe, which was about permanent residents who weren't given permanent teaching contracts in the Northwest Province, had to extend it to them. Union of Refugee Women said asylum seekers and refugees, not in quite the same category as non-citizens, but can't be completely excluded from the right to work, and that's about registering as security workers. And they found there that you can place some obstacles in terms of accessing work, but you can't make it a blanket prohibition. And then, of course, the most recent case, which is quite controversial, the case of Rafoneke versus Minister of Justice, which you may or may not know was about legal practitioners. The Legal Practice Act says to register as an attorney or an advocate, you must be a citizen or permanent resident. And this was brought by different forms of temporary residence on work permits and spousal visas. The Constitutional Court said no, it's perfectly acceptable to exclude permanent residents. And there was some debate about the interplay between unfair discrimination, immigration policy, and labor policy, which somebody else should come and talk to you about because it's really complicated, but really important and really interesting. So, and then finally, the third group that has been been successful have been women, right? Women brought most of the cases. And who were these women? They were mainly women in under-recognized and unrecognized relationships and marriages. So women in customary law, women in Muslim personal law, women in heterosexual cohabiting relationships. So we know that women have traditionally been stereotyped as carers of children. They belong in the home, responsible for the family, objects of male desire and control. In South Africa, this was exacerbated under colonialism and apartheid, so we know customary law was under-recognized. Customary marriages were called customary unions. Women had the status of children in those marriages. Muslim marriages were not even recognized, so the children were not recognized, etc., etc. Cohabiting couples, you still don't have a lot of rights. There was no such thing as a common law marriage, which was a shock in Fawkes versus Robinson to most of my middle-class educated friends that actually cohabitees don't have rights. Still don't have the kind of rights that they should. All of those people went to court. So cohabiting couples were not successful in about 2004 because the court said, well, you chose not to marry and you must live with the consequences, which was a fairly unsympathetic and conservative response, but there it was. But 20 years later in Bwanya, the court accepted that it had been wrong, so the court did accept that certain rights extended to cohabiting couples, but they're only rights of intestate succession and maintenance of surviving spouses. But fairly powerful cases brought by women in customary law, correcting the gaps in the Recognition of Customary Marriages Act, brought by women living in Muslim relationships, winning piecemeal reform, and ultimately getting the Constitutional Court to say to government, actually, that law that you've had on your books for 20 years, sitting in the South African Law Reform Commission, to recognize Muslim personal law and extend equal rights to women and children, that law you must now enact. So women had to, the most vulnerable women had to go all the way to the Constitutional Court to get legal protection. Most recently, the case of Mhlangu that you'll all be familiar with, the exclusion of domestic workers from compensation for death or injury, wasn't opposed by the government. Everyone thought it was a good idea that they should be included, which means that the judgment itself is a really progressive, really good judgment on intersectionality and transformative substantive equality, because the court had the space to be able to do it. So let me just wrap up. So when we think about inequality and the Constitution, what am I saying? Well, I'm saying we can't blame the Constitution. The Constitution is a tool. The Constitution has provided an important, although maybe not as robust and substantive as I would like, but an important defense for positive measures and affirmative action. I do think there's jurisprudential work that needs to be done there, both in relation to Section 9.2, but also in aligning the Employment Equity Act with the conceptual framework of Section 9.2. It's been incredibly important for the lesbian, gay, and bisexual community, for women in all kinds of marriages. Even in civil marriage, women have gone to court to correct defects. For some categories of non-citizens, to win rights that they would not otherwise have won through Parliament. So again, that tool to be able to fix up our regulatory framework, particularly in family law, has been critical. I do think that if I were talking not too late, well, I do wonder why I don't see more cases on sex and gender discrimination coming up through the labor courts. That's my one question to all of you. Surely there's gender and sex discrimination. Why are the labor courts not being used for that? Women have used it in so many other areas. So that's a question for me. I also think that the Equality Act is a really important tool which allows us to begin to address discrimination in the private sphere, inheritance. Well, that's happened already, right? There's 2 cases on inheritance that have outlawed discrimination for particular kinds of for children who adoptive children and women in inheritance. But insurance, medical aid, there are all kinds of areas where the Equality Act really offers a useful tool outside the Employment Act or alongside the Employment Equity Act to begin to address discrimination that you see. There's my timer. And it also has an incredibly creative list of remedies, ranging from an apology, and we've seen people resistant to giving apologies and eventually having to do so, to orders that actually ask enterprises to examine themselves, to examine their discriminatory practices, and to put in place plans to do it. So yeah, I think that's a really important pathway. Thank you, everyone.
Thank you very much for that presentation, Prof. And of course, ladies and gentlemen, a quick reminder, straight after our presenters finish, all these presentations will also be uploaded on the ELRC's website, so you can access them there. So let's continue. After that presentation, we'd like to call upon Ms. Sibego, and she's an economist and researcher. She'll be talking to us about unemployment, poverty, and inequality in South Africa.
Good morning, everyone. My name is Busi Sibeko. And as already noted, I'm an economist, so a bit different from what you've been hearing today or the past 2 days. But I want to contextualize you as a worker in the economy and your students as future workers in the economy, right? We're not just workers. We are people who go home, who need electricity, who need water. We are part of social relations. And I sometimes think when I meet with unions, a lot of the focus is us as workers. But we are also consumers. We are also people, civil society really, in communities. I don't see my slides yet. Okay, so I'm going to talk to you about the macro. I always like to start with this quote, because even as an economist, I have to remind myself that capitalism isn't the status quo. And it says, we live in capitalism, its power seems inescapable, so did the divine rights of kings. Any human power can be resisted and changed by human beings. Resistance and change often begin in art, and very often in our art, the art of words. So I begin with this because I think what I say as an economist is very important. And if I reaffirm the status quo as the norm, it reinforces certain norms that we live in. So, I don't know how many people, of course, the people who were here in 1994 know it was great, it was beautiful. We had very progressive economic policies that we were thinking of. But these didn't happen. A lot of people don't know this fact. But in South Africa, in 1994, we actually had a lot of debt. I don't know if many people remember that. We paid off this debt until 2002. And what does that mean? It means that we actually spent a lot of money paying debt instead of investing in our new democracy, right? So some people argue it was odious debt. Why did people give us debt to sustain this problematic system? Why would people give us the financing for a problematic socioeconomic dispensation? So as you can see there, our debt was about 29.7 billion US dollars, that's in 1994, which is about 50.4% of our GDP. Does anyone know what our GDP today is? Higher than this, but this is where we begin. So what is interesting to me about the political economy of our country is this idea that we had two camps. We had a progressive camp that went to study for a heterodox future, and we had some people who went to study at the IMF and the World Bank. And guess who became team finance? The ones who went to the IMF and the World Bank, which is important because that's how we understand why our socioeconomic policies are the way that they are. Here, I want to emphasize to you all that what happened is that we adopted what is a neoliberal, the professor already mentioned, a neoliberal capitalist model into economic policy making. So what does this mean? And I categorize it by 4 areas: stabilization, liberalization, privatization, and rationalization. And why is this important? Especially in the education sector globally, the idea is that the private sector can provision what? Education better. What private sector can always deliver what? Services, right? Better than government. But this is obviously an approach that has been taken. It does not mean it's the best approach. It does not mean it always works best. But that is the global heteronormative framework for economic policy making. So in South Africa, what happened is that we adopted these policies. But what that also meant is that we focused a lot on the supply, right? Supply of workers, skills, and so forth. But what has happened in South Africa is we've got a lot of supply. I'm pretty sure you educate a lot of great people. Are they employed? Right? So just because you supply doesn't mean there's a demand. And so all of our policies are focused more on the supply side of the economy rather than the demand side. So really the rest of the slide here is just saying that we've had also rapid financialization in our economy, which is why our real economy meaning where the jobs, the brick and mortar is, right? You know, the people building the buildings has not been invested enough in, which is why we've got infrastructure backlogs, which is why we've got all these other issues in the economy. So, as the former, advisor really in the president also acknowledges that what we did is we self-constrained ourselves through gear in the 90s by implementing what is called austerity. I've written a lot about austerity. What is austerity? People always ask me, what is austerity? Austerity, in simple terms, is economic policy that is adopted during a period of low growth to deal with debt. So remember, I said from the 90s, what have we been doing? Dealing with debt. What does that mean? We've been cutting expenditure or not spending enough. Right? So from the beginning, 1994, we've had an austerity approach to our public finances, right? So even in places where we could be spending more, we have not because we feel like we don't have the money, right? Have you heard, the minister says this a lot. Who's heard the minister say we don't have the money? Right? You've all heard the minister say we don't have the money, we need to tighten our belt, right? But really what it means is that, and then I think most of you will recognize that what you think you've saved today is a cost in the long run. If you don't invest in a child today, what's going to happen in the long run? You're going to have to support them through the state anyway. So the short-run savings don't mean long-term savings, right? But enough about the history and so forth. I just want to show you here a highlight to say, look at what has happened in real GDP growth. In South Africa, we talk a lot about growth, right? We've been talking about growth forever. But if you see there, our growth has always been lackluster. The more we do the same, the more we get what? The same. So the more we implement neoliberal economic policies, the more we're not getting the growth outcomes that we want. In the education sector, education is less than 5% of our total GDP in South Africa. So if growth is not growing, it means our investments in the education sector are not what? Growing either, right? So this is what's happened with growth over time, and everyone always asks this. So between us, GISA, GEAR, I always like to ask, I usually talk to students, so I like asking people questions. What is the current economic development plan of South Africa? What's the document? You know, back in the day, it'd be like, we're in ASGISA, we're in GEAR. What are we in now? Most people don't know. And that's a problem, right? The plan, the blueprint, is the National Development Plan. But even that is different from what we've seen before. The National Development Plan is not very clear on what the economic policy is. It tells us what the outcomes will be, the growth outcomes, we're going to invest in infrastructure and so forth. But we are in an era, I think, in a very long time where we don't, an average person in the street doesn't know what our economic plan is, which is a problem. So I start here because as a feminist political economist, or someone who identifies as a feminist political economist, I think it's important that we talk about economic history. We do not begin our economic history today. Of course, there's path dependency. We know that a number of things have happened, which I'll also cover in this presentation, but really to say that economic institutions are not neutral, that there's patriarchy. We're talking about sexual harassment, women in the workforce, and I think through this presentation, I hope to link some of these neoliberal capitalist logics and why we see some of these issues that we see in your fights for bargaining, right? Some of these issues. If you're in a context of austerity, of course, arguing for higher salary means what? You're not going to win, because the state has already decided that this is what we will spend on education, right? There's a reason why there's so many teachers who don't have jobs. There's a reason, right? It's because we've capped expenditure ceilings, mean the education sector only gets a certain amount of money. And that's part of a broader economic decision. So social reproduction, and this is why I started by saying that we all get here. We are not just workers. We socially reproduce ourselves. We got here this morning because we bathed, which is an economic activity that's underrated, bathing. We got here because somebody raised us, which is another economic activity that is underestimated, that most mainly women do. There's a great paper on breastfeeding, by the way. I was telling my friend the other day, I said, you know, breastfeeding is an economic good. And she said, what do you mean? And I said, people have actually written papers and estimated how much it would cost, and you compare it with how much you buy for milk, how much women are producing as labor at home, right? So we're not just workers in the workspace, we're workers at home too, in many ways, right? We're workers everywhere, we're always working. So unemployment. I like this quote by Marx. It says that it is the very nature of capitalist mode of production to overwork some workers while keeping the rest as a reserve army of unemployed paupers. What does that mean? It means that we will always have unemployment. That is the structure, nature of capitalism. It means that we'll always have fewer teachers in the sector because some people need to be at home, right? To overwork some and exploit others. It means that in the private sectors that there have to be unemployed people so that you can exploit them for lower wages, because people are willing to take on jobs because they're desperate, right? So to me, really, we always have to look at unemployment as a structural feature of capitalism. I know we talk about full employment, but I can tell you now, we will never reach full employment in this structure. That's the reality. A lot of people have never really looked at the definition of unemployment, and I like to remind people, because when we look at the numbers, we are talking about people who fall under only these three categories, which is not in employment, right? Not in work for pay or profit. So if I work at my dad's tuck shop, am I employed? No, right? Because I don't get a profit or a wage, but I work. If you have to be seeking for work for pay or profit. So when Stats SA asks you, have you looked for a job? If you say no, guess what? You're not in the unemployment figures, right? And you have to be available to work. So this is the definition of an unemployed person. And we know in South Africa, obviously, that there are a lot of unemployed people, 8.2 million in the recent statistics. But we also know that there's a lot of people who are discouraged workers, which is those people where they ask them, have you looked for a job? And they say no. And then they put them in what? A different category. So when you look at the unemployment figures, they're not reflective of how many people are unemployed, really, right? So we've got a huge unemployment crisis in our country. But I also want to show you this trend, which is that unemployment has always been high for a long time. I think sometimes we talk about it. It's a protracted crisis is what I'd call it. It's not a today, it's not the last 10 years, it's so forth. But it's really, we've had a high unemployment rate for a long time. And some people will say, no, but we had a lower unemployment rate in 1994. And then I say, but it's because a lot of black people were undercounted. So it's not that it was better, it's that we were undercounted there, right? So it's only 1996 that Stats SA actually starts to pick up. So a lot of the data you look at historically begins really in 1996, where Stats SA starts to pick up on data. But importantly, people ask me, oh, what happened between 2004 and 2008? Why is unemployment reducing there? What must we do? And I say we didn't actually do anything different. It was favorable world conditions. So in all these years, I don't think we've ever done anything from a macroeconomic policy perspective to reduce unemployment. We've just been lucky, right? So here, I think it's important, spatial apartheid, we talk about this a lot, but we all know this, right? People who are in poorer provinces, which is part of our history of development, where development was happening across our country, obviously have higher rates of unemployment, right? So I like that SA has added the expanded, which now includes those people who are discouraged workers. That's why we have an expanded rate. But the official rate is obviously lower than the expanded rate. So of course, Northwest, Eastern Cape, Free State have higher unemployment rates. And here, the gendered nature of unemployment. There's a great writer. If you ever read an economics book, please read The Caliban and the Witch. I know it sounds weird. The Caliban and the Witch is what the book is called. But it's the history of capitalism. And what Federici says, she says the construction of a new patriarchal order, which is under capitalism, making of women the servants of the male workforce was a major aspect of capitalist development. On its basis, a new sexual division of labor could be enforced that differentiated not only the tasks that women and men should perform, but the experiences, their lives, in relation to capital, right? Our relation to capital, gendered, is different. And so here she talks about, and she goes on to talk about the division of workforce and how it really helps capitalism, right? The reconfiguration of a gendered nature, which we didn't necessarily have before. It's part of capitalism. And I always say, what does capitalism start with? It's a test. What is the first step of capitalism? If I'm a capitalist, what do I do first? I take the land. Step one of capitalism, you take land. Why? Because you coerce the people to be part of labor, right? And then two, you divide the labor so that you can have someone to reproduce your workforce. Because if both women and men are at work, who's raising my future workers? For free, for me, of course. I want to benefit. So it's by design, right? It's not by accident. There is really almost a 101 how to be a capitalist, I want to say. So here, it's no wonder in South Africa that we've got high rates of unemployment by gender, right? Because we had obviously Bantustans, women still do majority of the unpaid care work. I've been doing some field work in informal settlements, and one of the things the women told me there is that they spend 2+ hours a day waiting for water. So when are they looking for jobs? These women said to me, if I didn't have to wait for water, I could be looking for a job. If I didn't have to take care of the children, I could be looking for a job. So when you look at the rates of how many women are graduating from higher educational institutions, we've got a higher rate of women in higher educational institutions, but look at the unemployment rate of black women there. Do you see it? Do you see how black women, African women, have the highest unemployment rate in our country? when we know that 70% of children live with their mothers, right? So important and sad stuff. But okay, this is the problem with economics. I know I studied economics, but I really like to critique economics. People call it the dismal science. I won't call it quite that, but here we are. The problem with economics is the assumption of a rational, self-interested, independent person who's got no responsibilities. Are any of you in this room, this person? No responsibilities. I wish I was them. So we don't have people like this, but all economic models assume this. They assume that you'll never get sick, which is why rights for sick leave and so forth come so much later. The logic of economics is flawed, right? What is a worker? So which is why unions become important over time, is to really challenge the assumptions of economics or what we are taught in economics, right? The assumption here is that you're going to be a full-time laborer lifetime. Who's taught those graphs that say like leisure versus wage? You know that EMS graph, leisure versus wage. Is that the only things we decide between? No, right? There's other considerations, but the assumption that you're going to be a lifelong participant of labor force, you're never going to get old. So labor unions have fought hard for us to have pension, to retire, to have maternity leave, to have all these different things, because the assumptions here are that you are basically a robot who is just going to work forever, right? But also the models are on this idea of homo economicus male is what I like to call them. They don't take into account children, elderly people, people with disabilities, the intersectional sense, because the assumption is this neutral human. A lot of it is obviously focused on math, so if you don't, I know my presentation hasn't had a lot of math, but I don't like presenting on a lot of math. I like to talk about policies. I think it's important to humanize economics. The numbers are there, but they don't always speak to the reality of people. So here, austerity and unemployment. So I began by telling you that you know, we've had austerity in South Africa, but austerity, the literature shows us, austerity drives unemployment up. So the more we're saying, in our budgets, we've been saying we're fiscally consolidating, which to me is austerity, since 2012. And what has happened to our unemployment since 2012? It's gone up. It hasn't gone down, but that is the result of austerity, right? And I like this book by Clara Mattei. She basically says that austerity is part of the DNA of capitalism. She says that it stabilizes capitalism, right? We always say capitalism reforms, it changes, it adapts. Now we want women in the workforce. Now we want to, you know, everybody must go to creche now. Because why? Somebody's benefiting from that system, right? So there's always a way in which capitalism reforms itself. And so she talks about how austerity is basically an automatic stabilizer of capitalism or the capitalistic system. So going on from here, and then in a paper I wrote in 2019, I say that austerity has been used to legitimize a desire to shrink the social welfare of the state, deregulate labor markets, emphasize private markets as the drivers of growth, and enable reconfiguration in the interest of capital, particularly the financial sector, which I stand by today. This is now 6 years ago. I still stand by it. Why? Because what is happening is that all our budget documents are saying who must drive growth? The private sector, right? Who must save South Africa? The private sector. And what is happening in the state? What must happen to the role of the state? It must shrink, ne? Why? Because private sector will provide, right? So that's the great thing. So on poverty, here there's a great quote by a feminist economist. Her name is Naila Kabir, and she says the processes of poverty can be divided into those which explain why poor people remain poor over extended periods of time, the so-called poverty trap, and those which explain people, both poor and non-poor, become poorer over time. Do you guys feel like you've become poorer over time? Is that the feeling? I feel like the electricity prices alone make me feel poorer over time. Every year, the tariff increase makes me feel poorer over time. The cost of food, right? The cost of living crisis that we face as workers. So in South Africa, of course, we can talk about multidimensional poverty. And what is always interesting to me is that the president always reminds us that the face of poverty in our country is the face of an African woman, right? And that obviously poverty patterns are gendered. But I think what is interesting to me is that in the 90s, South Africa was one of the first African countries to adopt gender-responsive budgeting. Why did we abandon it? We abandoned it because we oversubscribed to a neoliberal policies which are in contradiction to what gender-responsive budgeting is trying to do, right? You can't have a transformational tool and at the same time be implementing a tool that is neutral, right, at the same time. So it makes me sad because I think if we had really gone on with this, we would have very different reality in South Africa. So as we know from Stats SA, the typical profile of a poor household in South Africa is headed by a Black African female under the age of 35 in a rural area with lower levels of education and most likely to be unemployed and situated in lower income quintiles, right? So these are statistics that most people know. And then there's a great study recently that shows that 60% of the black population faces severe deprivation, and this is when they're taking into account basic services and so forth. I've got a slide that will talk about basic services in a bit. So here's basic services. In some areas, we're seeing an increase, right? So municipalities are important. We know that we've made significant progress, right? Like if you look at the data from 1994 to now, you can see more people have water, more people have electricity, more people have generally basic services. But what has happened over the last 10 years? Rates and taxes have increased by 118%. Have our salaries increased by 118% in 10 years? Electricity tariffs by 177%. Water tariffs by 213%. So the increases in our rates and levies at a municipal level are outstripping our salaries increases, our wage increases cannot keep up to these things, right? So people are having to decide between food and electricity, right? People are having to decide whether to eat or, I mean, luckily municipalities don't shut water off as often because it's a basic right, but electricity, they're definitely going to be quick to shut you off and disconnect you. So people are having to make hard decisions about how to reproduce themselves on a daily basis. But here on the graph on your left, what you can see is that the number of people who've gotten water has increased in 10 years. You see that the number of people actually getting electricity has decreased. Why? People are getting disconnected. Sewage and sanitation is lower. Solid waste management, great. They are picking up the trash. It's nice. But what I want to show you really is that the bottom graph is showing the number of households who are getting free basic services. And that number, despite poverty, inequality increasing, is actually decreasing over time. Municipalities are giving less and less households free basic services. And there's a complexity to this. It's because municipalities have been tasked with not only provisioning water, these basic services you see here, water, electricity, sewage and sanitation, and solid waste management, but municipalities are also supposed to do economic development. You know how much money municipalities get from the national out of the total budget? Less than 10% of national revenue goes to municipalities. Less than 10%. And they're supposed to provision all of this and raise their own revenue, which is where the challenge is. The assumptions of the white paper is that people are going to be employed, and because people are going to be employed, they're going to pay for services. But what has not happened? The employment part. So a lot of people can't afford to pay for the services, right? It's supposed to be a user pay model. So time poverty, and a lot of people don't talk about this, but I always want to talk about time poverty, which is really about the work, the unpaid care work, the invisible work, the work that is done to keep society as it is. I think COVID-19 showed us how important unpaid care work in the household is. When children were at home and everybody had to take care of them, teach them, do all the work, it's nice to send your children to school. But when they're here and you have to do the work, it's not as nice, right? But also communities really galvanized and took care of each other. And this we also have learned in South Africa because in the HIV and AIDS pandemic, it was a lot of women who left their jobs to go take care of family members, right? It was a lot of women who really took on the community work. And this work that people do is not counted in the gross domestic product, GDP, right? Which is why I think economic policy sometimes ignores that work because it's taken ultimately for granted. And also to highlight that because, you know, I don't know how many of you have children, just raise your hand. If you have a child, male or female, male or female, do you get to take a day off from your child? Do you get to be like, sorry, today I'm... So the thing about unpaid care work and why it's important, and I think for labor unions as well, is that when you situate yourself in a community, you understand that there are people doing work who are not going to get a pension for this work. It's 24/7 work. There's no leave days. There's no sick leave, right? If you're sick and your child comes to you, you don't get to say, I'm on sick leave, right? there's no benefits of being a worker in the formal sector, right? So a lot of what feminist economists worry about is that women who are traditionally called housewives, what does it mean for their long-term journeys? Like what happens when you're in retirement and so forth? So we have to acknowledge those kind of work. But also, Seguina shows how gender inequalities perpetuate the crisis of social reproduction, which is the reproduction of society as a whole, and how it has detrimental economy-wide effects, right? So education, health, all those sectors, which are also part of the care economy, are usually under, it's easier to cut money from education and health, because if people are sick, guess who's going to take care of them? Women at home. Right? There's always a buffer. Women are the buffer where there's underinvestment in some of these sectors, especially creches. But anyway, just to move on here, I know I've got very short time left. But to say here that in our country what has happened is, and when I worked with unions, I used to say, you should be the front line supporting a basic income grant. Why? Because as a worker, if a household in South Africa has 4.4 people, and you're the only worker, guess what's going to happen? Your money also then has to go to all these people, right? There's intra and inter-household, black tax, whatever you want to call it. But when your grandmother, you know, is going to get the grant, what does it mean for your salary? Right? So I've always said that we see it as a negative thing, but I also want to highlight here that we see grants as sort of this like dependency thing, but look at the numbers. The majority of recipients are children. Do you see that? 13 million people who receive grants in this country are children. So we have to debunk this myth that working people are getting grants. 13 million people, children are vulnerable in our society. Studies show that children whose parents or who get grants are more likely to access education, are more likely to be nutritionally better off. We know that actually child grants, there's a lot of studies that showed that it's actually our big bang for our buck in our budgets. The big bang for our buck. We are getting the returns with children, right? Then we've obviously got the old age grant, which is about 4 million people. And I like to remind people that, you know, there are a lot of people who worked in apartheid for a very long time who do not have pension. These people are not just pensioners receiving government aid just because they've never worked. These are people who worked who didn't get their benefits, right? These are people who labored and didn't get their benefits. So we have to rethink how we talk about old age grants and grant system broadly, because it's reflective of our path-dependent economy and socioeconomic statuses. Foster care, I always ask them. Also, what I find odd, why is the child support grant growth so low? Why is Treasury underestimating the child support grant? Your class size is only growing by 0.2%. I don't think that's what's happening in our society. So there's also a thing that we have to ask and get our National Treasury to be more accountable, which is, where is this number coming from? Are you taking more children off child support, which is also a threat to those children's, you know, rights, nutritional rights, social assistance rights, or what's happening there? And the care dependency and all of them are obviously going down. So the COVID-19 SRD, which is, you know, as everyone knows, the 350, now 370, they plan to cut it off. But I think that, you know, for me, I think that the big argument is that we need it, right? The Constitution, we just spoke about the Constitution. The Constitution in South Africa says that, you know, everybody has the right to social assistance. It doesn't say if you're only under 18 and over what, or, you know what I mean? It's very specific. It says everyone. Everyone. And I think I'd like to think our Constitution, where it's clear about everyone. Where it says citizens, it says citizens. There's much clarity about that. So, you know, it is a constitutional right, and a lot of the language tends to be about the deserving poor. Who is a deserving poor person? Who is a deserving poor? Right? Or this idea that like, and I think that grants go against this anti-poor, anti-black, but also anti-woman sentiments, because when we talk about child grants, we're not talking about the fathers who are not supporting their children, who've made the children, right? Who gets the grant? Mostly the women. So there's something about the way we talk about grants as a negative thing, which absolves men for their duty or how they were part of the procreating of those children. It's always the woman's fault. Why do they get a grant? So I think there's a ways in which we talk about grants that is very problematic in our society, but also understanding that grants are a symptom of our socioeconomic context, right? If we do away with grants, I don't even want to say what will happen, what people will do in the streets. In real terms, so if you adjust them for inflation over time, they've actually not increased since 1995. Except for the child support grant increases quite a bit from 95 to the late 90s. But all the other grants have actually been outstripped by inflation. You see there, so those are the grants, and you see the old age grant is actually lower than it was in 1994. You see there all the different grants and all their trends. So sometimes you see the grants increasing, but when you adjust by inflation, they're actually not increasing. The value is not the same as it was. So inequality, I've got, very short time. But anyway, I want to talk about corporates. I think in South Africa, we talk a lot about inequality, the states, the people, the what. But I think it's important that we talk about corporates in our South African economy, because there's a lot of market concentration. If you think about, for example, the Foschini Group, how many other companies they own? A lot, right? So we've got few people own a lot of the businesses in South Africa. So there's a lot of market concentration, which in economics would say it's an oligopoly, right? And so the South African economy has become more financialized, as I've already said. And then when you look at the JSE, you see that there's a lot happening that is merging a lot of these big firms. And so that's a problematic in our country. And why is it problematic? Is that you don't want oligopolies, because then the wealth and income is in the hands of the few. But not just that, what we also know in South Africa is that companies don't pay their fair share of tax. What is the statutory rate? 27%, right? But when you look at the Davis Tax Committee, what you learn is that in the mining sector, the effective tax rate, what they actually pay was below 15% of tax, right? And in other sectors, it was 18.2%. So we've also got a lot of corporates that are not paying their fair tax, which means that government is saying we don't have money. But it's because of this kind of exploitative system. Here, when we come into race and income inequality in South Africa, what you see is that the bottom 50%, so half of South Africa, only has 5.3% of the income. The NDP target is 10%, which is still very low. But 5.3%, so half of the population only has 5.3%. Imagine that. The top 10% have 66.5% of the total income. So as we all get our salaries at the end of the month, and it's nice, other people are holding 66.5% of our country's wealth, right? And then when you look at the wealth inequality, what you see is that a lot of the bottom 50% have negative wealth, which means after people pay off their debts and, your car, your whatever you have, you actually have negative 2.4% negative wealth. The top 10% have what? 85.7% of the national wealth. So we've got deep inequality in our country, right? And so when we talk about redistribution, which is part of that constitution, and I always ask, when we ask what's happening with the national budgets every year, we have to ask that question of, how are we redistributing this? To me, that's the fundamental question. How are we redistributing? Here, this is some great data from the Income and Expenditure Survey by Stats SA, which is available. But here we kind of show some of the quintiles and groups. And of course, we know that Black Africans tend to be more concentrated in the lower it's actually more distributive across the different quintiles. But then we also know that the white population, 73.2%, are in the upper quintiles of the income spectrum. Of course, we know that there's few people who get the income, and then I'll show you the next graph. There's a lot of graphs. I like graphs. I mean, most economists like graphs. That's the one part I like. But here, I think what is important in South Africa is to show you this. I don't know if this shows a laser. Does it have a laser? No. Okay, but to show you here on the left, right, that's what the bottom 40% spends on average. The bottom 40% spends 170,584 Rand a year. Nah? When you look at the top, I can't see it now, top 10%, they spend more on just their housing, water, electricity, gas, and other fuels than the bottom 40 spends on their total budget. So they spend just that much, just on water, electricity, and the basic services, than the whole population spends there. So that's some of the inequalities that we are talking about. You'll see, obviously, that food and non-alcoholic beverages are quite a big, significant part, but you also see that for the bottom 40%, housing, electricity, and so forth are a significant share. Those two bottom, graphics there, or the bottom of that, show you how much they spend. Okay, here on a racial basis, Again, I mean, I don't think I'm showing you anything new. I think I'm just showing you more of the numbers. I think everybody knows this theoretically and practically. But really to say that Black African households, their consumption on average is 108,464 Rand each per year. Whereas when you compare it to those, so white households spend almost 4 times that per year, and Indian Asian households spend more than twice that, and colored households spend just almost twice that. On land, and I'm concluding now, but to say that I think sometimes we shy away from talking about land, but land is an important way in which households can survive, right? So I said the first thing that capitalists do is take away land. Why? Because it coerces you to work. But if you have land, you can also grow your own food. You can also self-sustain in different ways. And so really to say that, you know, in South Africa, we continue to have the question about land. When you look at the 2017 land audit, you find that males obviously have more land than women. We spoke about the, you know, the what is the word now? In traditional land, I'll call it, for lack of better words, but we also know it's gendered and racialized, right? So land remains a significant topic in South Africa that we don't talk about a lot, right? And it affects all the dimensions of our social reproduction as a society. Land crisis. I looked at a report by City of Ekurhuleni. They say they've got 117 informal settlements. We're in the city of Ekurhuleni right now. There are 117 informal settlements. People are desperate. People don't have land. The informal settlement I'm doing my field work in, they've been temporarily placed there for 2 years. We don't know what temporary is. They might be there forever. They might be there for 5 years. They don't know. And their stands are literally from here to here. That's where people have to live, right? So land remains a big issue in South Africa. So really to conclude, to say that unemployment, poverty, and inequality are not outcomes, but rather a process, right? So we don't just wake up with a high unemployment, poverty, and inequality rate. That because macroeconomics is about aggregates, which is a problem, it assumes neutrality in many ways, which is why we see a lot of some of the issues in our society, which is that we haven't adequately in economic policy taken into account the distributive relations. We haven't taken into account the social groups, intersectionally so. We haven't looked at power asymmetries between men and women and so forth. And then we haven't looked at the historical, social, economic, and political processes and how they're path-dependent and perpetuating, reproducing the inequalities that we see in our system, but also that the economic system itself is reproducing systemic inequalities in many ways that we see today. So I'm going to end there. Thank you very much.
Wow. Thank you so very much for that sobering presentation, Ms. Sibeko. Quite informative. Thank you so very much. Yeah, round of applause again, yeah. All right. Yeah, and Ms. Sibeko is an economist and researcher. Thanks very much indeed. I'm looking forward to the engagement session as well at the back of that. Now I'd like to call upon Mr. P. Sawa, who's going to talk to us about the publication of the South African Schools Act as amended. This is the Bella Act, quite a contentious one. Mr. Sawa, over to you.
Program Director, Mr. Masangu, the Chairperson of the ELRC, Advocate Bono, the GS of the ELRC, Dr. Fulka, distinguished speakers and guests, ladies and gentlemen. Thank you for the opportunity to address you. The CTU-ATU expresses its sincere appreciation for the platform and the opportunity to express some of its views. The theme of this seminar is appropriate, adapting to an evolving labor landscape to promote social justice. Many of us present today have been part of the labor landscape for the past 30 years or more and can testify to the adaptations that have taken place as the labor landscape has evolved. The establishment and development of the ELRC itself, the development of a labor dispensation, especially within the education labor relations sector, and the extension of the influence of the Council to the present day are achievements we can all view with satisfaction. The CTU recognizes with thanks the forward-looking progress within the ELRC under the guidance of the Chairperson and the GS, as well as their predecessors. And we look forward to being part of the ongoing developments within the sector. I'll be speaking on the theme, the publication of the South African Schools Act as amended, the Bella Act, as a significant contribution to the advance of a culture of human rights in schools. The South African Schools Act has been materially amended in a number of important respects. A good deal of public debate took place as the relevant amendment bill was made available to the public for discussion, and it will be recalled that aspects of the debate were acrimonious, both in the public space as well as in Parliament. Political parties made use of the period of public debate as an agency for securing political advantage, while role players and stakeholders in the schooling system raised their voices, at least in part, to culminate the education authorities sponsoring the amendment bill. It is not my purpose to take sides in considering aspects of the South African Schools Act in its amended form. The Act is in place, and the road going forward will demand of all concerned a higher order of involvement, of concern, and of very hard work to try to ensure that the provisions of the Act in its amended form are implemented as fully as possible. Section 29 of the Constitution of the Republic of South Africa is justiciable. It confers certain rights on all who fall within its ambit, and if those rights are not recognized and were necessarily advanced by the responsible authority, those who are negatively affected can seek redress in the courts of justice in the land. It is therefore of cardinal importance that the additional burden on the state created by at least one of the amendments, the legislation, be recognized and understood. I shall refer to 3 amendments in the view of the CTU-ATU, which indicates the extent to which the lawgiver has given cognizance of human rights issues. I shall deal with them, 2 of them briefly, and then concentrate on the 3rd amendment that I'll be speaking about. Corporal punishment. The amendment of Section 10 of the Act strengthens previous provisions with regard to corporal punishment. Corporal punishment in any form has long been prohibited in South African public schools, but aside this prohibition, there have been instances of corporal punishment reported and which have been investigated at provincial levels, for example, in the Free State, Gauteng, KZN, and the Western Cape. There have also been investigations by the South African Human Rights Commission into persistent aspects of corporal punishment. The amendment of Section 10 strengthens the terms in which the prohibition is cast and serves to emphasize once again the commitment of the education sector to the abolishment of corporal punishment in schools. Inclusivity, the second one. Inclusivity refers to the practice of providing equal access to opportunities and resources for people who might otherwise be excluded or marginalized. The education authorities themselves refer to the following aspects of the Act as constituting avenues which will advance inclusivity: language policy and diversity, access and equity, safety and welfare, governance and accountability, and addressing discrimination and promoting tolerance. Inclusivity has been a cardinal component of education legislation, and much work has been done to advance a culture of inclusivity in the various realms referred to above. Equal access, as cited in the above definition of inclusivity, implies that equality and sameness are not the same thing, and access that is equal implies more than anything else access that is equitable. That is, access which is fair. It might be argued that the giving 2 pupils access to the same school promotes equality. The question might be asked as how equitable such a decision is if one of the pupils lives around the corner and the other one has to travel many kilometers away by bus or taxi to get there. Equal education must include the notion of equitable education, and until such time as all public schools in the country operate at the same standard, reference to equal education is less of a possibility than one would hope for. The third issue I refer to, and this constitutes the greater part of my presentation today, has to do with Section 3 of the Act. My intention is to show that the contours of the basic education system has been materially altered by the Act, and that the constitutional obligations of all parties to the basic education and schooling system have been materially altered and expanded. The theme falls naturally into 2 parts. First, the argument will be the amendments of the South African Schools Act have redefined the formal organization of preschool education. Second, the constitutional imperatives which arise from this redefinition will be examined. And arising from the analysis, I shall in the third place be considering some recommendations. ECD, early childhood education, is usually considered to span the age range from birth to 8 years of age. While there are varying views about the precise meaning of the term ECD, in South Africa, the formal schooling system was until recently divided into 4 phases equal of 3 years of length. 3 years in the foundation phase, the intermediate phase, the senior phase, and the further education and training phase. The 3 years of the foundation phase are typical described in grade 1, 2, and 3. And in terms of the provisions of the SA Schools Act, prior to the 2024 amendment, constituted the first 3 years of compulsory schooling. Early childhood education, therefore, consisted of a 6-year period commencing at birth, the final year of which was a preschool year designated as the reception year or grade R, and during the 6-year period, various types of provisions were made for the neonates, toddlers, and young children in the age group. Schooling became compulsory from grade 1 onwards. I emphasize that any and all forms of provision of schooling prior to grade 1 did not place a burden on the state in terms of the duty to provide basic education. The categorization has now changed as a consequence of the promulgation in 2024 of amendments to the SA Schools Act. And for purposes of this discussion, I want to refer to the amendment of Section 3. Section 3 of the SA Schools Act reads as follows: compulsory attendance. Subject to this Act and any applicable provincial law, and every parent must cause every learner for whom he or she is responsible to attend school, starting from grade R on the first school day of the year, in which the learner reaches the age of 6 years, and not leaving school until the last school day of the year, in which the learner reaches the age of 15 years, or will complete grade 9, whichever occurs first. The practical effect of this determination is that the period of compulsory schooling has been lengthened by 1 year. In short, the period of compulsory foundation phase schooling has been lengthened from 3 years to 4. From this point onwards, the state has inherited a constitutional duty towards the additional children who technically qualify for admission to schools. An obvious question which arises is that what extent the Education Authority, having taken a crucial step in recognizing the constitutional right of children in the 5 to 6-year-old age bracket, will be able to give effect to its intentions. The general consensus appeared to be that children admitted to grade R differ substantially from older pupils in terms of their developmental and related needs. Play forms a large part of their daily curriculum. Organized rest periods are essential. Learning by doing is of importance. Bonding with a significant adult is a crucial aspect of the process. Amongst other matters, mealtimes and regular and rhythmic programs are especially significant in the life of the young child. And the following of a sensible and meaningful routine is crucial. Grade R is not a watered-down version of grade 1. The difference between formal and informal teaching and learning processes is substantial. There are various, almost self-evident consequences of this alteration. I won't mention all of them here, but here are a few obvious consequences. A need for more teachers suitable, qualified to work with pupils, especially in grade R. A need for more physical facilities, especially directed at the needs of the grade R pupil. A need for an amended school management structure, which are able to deal with the unique characteristics of the grade R learner. A need for a national curriculum directed at the needs of the grade R pupil. A need for suitable education departmental support structures, and then a need for a system of teacher training specifically geared to the needs of the learners now being admitted. In a variety of its own documents, the Department of Basic Education summarized what it sees as being the functions in order to satisfy imperatives arising from its interpretation of the Constitution. Among these are the following. First of all, providing a functional education system. Education and schooling takes place at the local level. That is, the level of specific schools or educational institutions. The functionality of the schooling system is measured by the individual in terms of the way in which the local school functions. The education authority is organized into a national, a provincial, regional, district, and local structures, all of which have a role to play in ensuring that any specific school functions properly. The school itself then has a further role to play in ensuring that constitutional imperatives are adhered to. The state has hitherto never provided universal schooling at the grade R level, and in a sense, the new developments move the education and schooling system into uncharted waters. At the level of management, whether it be that of the school principal and the management staff or managers in other departmental structures, it can be expected that there will be a need to be preparation for the new and different challenges which await the school. Secondly, ensuring accessibility. Access has many facets. These include ensuring that the learner in question is able to reach the school, which may have implications on the establishment of new transport schemes or the amendment of existing routes. Within the school, access to fit-for-purpose facilities, such as classrooms, playgrounds, and playground equipment, is an essential part of ensuring accessibility. An essential component of access is the language of learning and teaching. It is yet to be seen how the policies to be determined by the education authorities in the regard will come to fruition and be implemented for grade R pupils. Thirdly, respecting the right to education and promoting the right to education. The establishment of grade R as part of a compulsory schooling by the education authorities can be interpreted as an action which respects the right to education of the grade R child. The promotion of that right is an entirely different matter. The cost implication of providing suitable facilities, transport schemes, feeding schemes, and learner and teacher support materials is very high. And it is at this stage unclear what the sustainability of the program will be in the longer term. The Gauteng Department of Education is currently calling for applications from the person seeking admissions to schools in grade 1 and grade 8 in 2026. There has been no call for applicants to grade R. Does this mean that the right to schooling of grade R pupils is not being respected, or that there has been some kind of omission in the system of the department? There's also a need for awareness programs and advocacy. There will be parents who have difficulty engaging with the notion that their child is now compelled to go to school, and that if they fail to see this obligation, they are liable. Fourthly, the provision of adequate infrastructure, already alluded to quite a few times. The learner in the school environment will need facilities suited for his or her own age group and the level of physical development. This includes aspects such as toilets, the height of wash basins and the floor, above the floor, positioning of drinking fountains. The Minister of Education has previously been involved in litigation relating to the provisions of facilities and has not yet satisfied all the requirements laid down in judgments handed down by the courts. The Minister has not yet published norms and standards for the provision of facilities for grade R pupils, and this will need to be done in a matter of urgency. 5, ensuring an adequate supply of appropriate trained teachers. All indications are that the availability of teachers to manage the additional load in the foundation phase is woefully inadequate. I have already made the point that the needs of the grade R child differ from those of older children. And I indicated that the approach to teaching and learning with these children differs from the followed in grade 1 and further in the foundation phase. The current training requirements for foundation phase teachers do not make provision for the skills and abilities needed by the grade R teacher. And these requirements will need to be amended. It is not clear what planning, if any, the authorities have in place to deal with enhancing the supply of adequately qualified and appropriately trained teachers. Challenges and risk. I want to turn briefly to what are known in the public education sector as unfunded mandates. That is declarations of intent by the education authorities on a project or projects to be implemented in the absence of funding or of sustainable funding. I will seek to show why this is relevant for our discussion on grade R. The education authorities introduced a program called the Integrated Implementation of African Languages. Many of the participating schools did so at their own expenses, although being posts provided by the department. The program has been currently terminated in the absence of foreign funding. The education authorities have for more than a decade been wrestling with a notional reorganization of the schooling system into 3 streams. The program has founded in the absence of reliable funding for the various components of the project. The Teacher Union Collaboration TUC project is used by the DBE as a vehicle for teacher unions to present teacher training programs on behalf of the department. The funding for this project is foreign-based. More than once, there have been fears that the project would not continue because of uncertainties about the funding. The Mpumalanga Boarding Schools project was launched as a flagship project by the Premier of the province, the late Honorable David Mabuza. The project is proving to be unsustainable. Of relevance to this discussion are the feeding schemes in the hostel schools, which have become sporadic and underfunded. A common thread running through these projects and others is a lack of funding and growing doubt about their sustainability. These are aspects of the Grade R implementation which bear a disturbing likeness to aspects of these projects which are in difficulty. For that reason, I would like to turn to the notion of reasonableness as a basis for constitutional opinion on projects of the state. The CTU-ATU has been a vocal supporter of the universalization of Grade R and believes that the amendments to the Act are necessary and defensible. At the same time, however, emerging from the brief analysis I have presented here today, it is clear that the implementation of universal Grade R schooling cannot happen overnight. This is a project that will probably have to be spread over a number of years. Section 3 of the South African Schools Act is immediately justiciable. There is no qualifying timescale for its implementation. The effect, therefore, is that individuals or organizations acting on their behalf would be in a position to litigate against the authorities. I want to say something here about the notion of reasonableness as a possible standard against which the Constitutional Court could assess government's compliance, as it is done in the case of some qualified socio-economic rights like social, security, health, and housing. The Constitutional Court has ruled that in order for a government program to be deemed reasonable, it must display the following characteristics. 1, be comprehensive and coordinated with a clear description of responsibilities amongst the various spheres of government, with the national government having overreaching responsibility. Secondly, be capable of facilitating the realization of the right. Thirdly, be reasonable both in conception and implementation. Fourthly, be balanced and flexible and make appropriate provisions for crises and for short, medium, and long-term needs. Fifthly, it cannot exclude a significant segment of society. And in the 6th position, it must include a component that responds to the urgent needs of those in the most desperate situations. And the state must plan, budget, and monitor measures to address immediate needs and the management of crisis. An application to review the reasonableness of the right to basic education has not yet been made. This means government compliance to meet its constitutional obligation with regards to the right to education cannot be assessed. Considering that this standard of reasonableness was established for a qualified socio-economic right, a case can possibly be made that an application to review the reasonableness of an unqualified socio-economic right, such as education, is desirable and probably necessary. Program Director, ladies and gentlemen, thank you for your attention. I want to repeat something I said in the outset. The Act is in place, and the road going forward will demand of all concerned a higher order of involvement, of concern, and of very hard work to try to ensure that the provisions of the Act in its amended forms are implemented as fully as possible. The CTU-ATU is committed to the implementation of all the amendments to the Act, also to Section 3 of the Act, and we shall do all in our power to help that come about. But to enable what is a dream for many to materialize, every party has to play its part, be it the parent, the learner, the school, a trade union, the education department, funders, researchers, or trainers, among the many parties involved. And together we need to ensure that these developments in the interest of our country will be able to rise to the challenges and overcome them. We have overcome massive challenges in our past, and I have no doubt that we shall overcome these as well. Thank you.
Thank you very much for that presentation, Mr. Sauer. It was quite informative. So now we're just about to get into our discussion session. Perhaps to just get things started with you, Ms. Sibeko. It was quite an informative presentation that you gave, quite sobering, as I also mentioned. And I think you spoke about the importance of what you called was humanizing economics. And you said this also starts by grounding it in lived experiences. For example, you made that example of the woman, who would be going out to, who'd say they'd rather be looking for work, but someone has still got to get the water, right? I guess my question would be, looking at measures as well as economic policy, and how do we fine-tune it in terms of redesigning it to better capture and value this kind of unpaid survival labor, while at the same time addressing the structural inequalities such as the gender divisions of work that limit women's economic participation.
Yeah. Do we just answer?
Yeah.
Okay, so I think that's, it's a $1 million question, because I think fundamentally what we need is to rethink economic policy. And I know it sounds broad, but when we envision what is an economy, what do we consider? The work that communities do, the work that women do, the work that men do to produce themselves, the work that is done, how do we reconfigure our society, right? So for me, social production is how are we organized to produce what we need to consume as a society, and how we organize to reproduce ourselves like the humans, right? So that really means that economics, how it's taught, how it's practiced, how it's thought about, has to be challenged. But that's not just a South Africa only issue. We are up against the globe, right? South Africa can't just say, sorry, we don't believe in neoliberal capitalist models anymore. There's a heteronormative structure, the World Bank, the IMF, which would obviously, push back and would. So I don't know. I guess the answer I always say to people is, I don't know. I do believe, to overcome capitalism has to be, Lenin, Marx always said, a global phenomenon.
Yeah.
I think that's where we are, right? Like, we can't just have it at a localized level. But I do think there's great examples of how people in communities are mobilizing and becoming, and let me give you kind of what I've learned from my research as well, is people are becoming less dependent on the state. So in this community where they don't have electricity, everybody has solar panels, right? Which means they don't rely on electricity anymore, which is one step away from the state. Like, so we, as communities, I think we are reconfiguring ourselves for the way to reproduce ourselves. And I think the more that happens, the more things can change. But I think women, even in those societies, continue to bear the brunt of reproducing society, and that's a whole patriarchy challenge that we need.
I'm actually glad we're having this chat on Women's Month, in fact. And I think, Prof. Alberton, you also made a very important point where you highlighted the global trend of which you said where economic distress coincides usually with a declining support for liberal values and leaders who weaken democratic institutions, right? So with those challenges, what strategies do you think are needed for strengthening democratic resilience, particularly, in protecting the judiciary, preserving the rule of law, and sustaining public trust in times of economic and social upheaval? I know you've touched on a few.
Yeah, well, I think it's very different if you live in America than if you live in South Africa. I think if you live in America, I think it must be very difficult to be somebody who cares about the rule of law and individual rights, because you constantly see the president pushing a door and going through because nobody's stopping. So the struggle there is actually how do you stop creeping authoritarianism and fascism, and I think a lot of people there are saying you go back to organizing and living within your communities, the kind of basic rules of resisting power. Whereas in South Africa, I think with all our problems, I think we've stood up and put our hands up for a global rules-based order and for the rule of law in South Africa. And however much things have gone wrong in this country, and I think the judiciary has done a positive job in terms of, and I think that however slow our president is, I think we are rebuilding some of the institutions. So, you know, it's that slow build of supporting institutions. And, you know, in America, they're going to have to rebuild their judiciary, in my view. You know, we're not there, and I don't think we'll ever get there, you know, but I think we have to be vigilant. So we kind of, yeah. So it's about civil society. I also think in South Africa it's been easier for civil society to hold government to account because of our Bill of Rights, because of our organized civil society, because we're a smaller country, because the courts have been responsive. So I'm not sure that's an answer, but it's a comparison.
Oh yeah, no, it unpacks it properly. Thanks a lot for that, Prof. So let's just bring it to the floor as well. But also, Mr. Gupjana, you touched on sexual harassment, which is another, you know, critical element of your presentation. And you said, at times, sexual harassment is quite hard to pinpoint, particularly in the workplace. Let's hear from you. What are some of the trends that you are viewing? And given all of this ambiguity with it, perhaps on a policy level, what sense are you getting right now insofar as making sure that we outroot sexual harassment, particularly in the workplace, where sometimes it's as subtle as you say it is?
Yeah, thank you very much. Yeah, you know, I checked and checked and checked again, I mean, in other countries, because obviously we need to benchmark. But to be honest, what I get more or less the same thing that South Africa is doing. But I believe that, I mean, we can do something. It's not always that, I mean, we need to follow. Yeah, we can be the leader, and then the rest follow us. And some among the things that, I mean, that came across my head as I was thinking of, along that lines, it was that South Africa is a country that is founded on, among other principles, the principles of the rule of law.
Yes.
Yeah. And then in developing the rule of law, in developing the law, we are guided by, amongst other principles, the principle of legality.
Yes.
That principle says, when you develop a law, the law must be clear, specific, unambiguous, strict, and specific. So, when you look at our sexual harassment, it doesn't have any of those.
Yeah.
Yeah. So it just always depends on who's sitting there, and usually sexual harassment, where it happens, it is in some corners.
Yeah,
It is,
and clearly still a long way to go as well insofar as that is concerned. Let's bring it now to the floor. So okay, just a quick intro, where you from and your question. Yes, go ahead. Where's the mic? Wherever the microphone is. Yeah, right here, the front. Thank you very much.
Yeah, no, thanks. Greetings to everyone. I'm Golani Dube from SATU. I've got only 3 questions, and they are...
Not 3.
Only
We
one.
have to narrow it down, please.
No, they are too short. They are too short, but I'll just break them down.
Who's it directed at?
They are directed to the second presentation and the third one, to Prof. Albertine and
Okay.
Ms. Bego.
Okay.
So just a quick one, Prof. Are vulnerable groups able to access courts or administrative remedies to claim socio-economic rights? And then the last one, because I had to chop them down, it's
Yes.
directed to our beautiful economist right there, Ms. Bego. Can spatial planning reforms realistically increase employment access for disadvantaged communities? Thank you.
Thank you so much for
Sorry,
that.
I missed the first few words. Can who
You were-
claim?
Oh, it was on vulnerable
the
groups,
vulnerable
right?
groups.
Vulnerable groups,
Yes,
thank you.
yes.
Thank you.
Yes. Can I just ask that we try and gallop it quickly? Let's get the next. Where's the next hand? Okay, right there, this side. Yes, please. Go ahead.
Thank you, Comrade Program Director. I'm giving you assurance that I'm going to be very brief and to the point. Standing is Nolo Babalo Ngete, Regional Secretary of Umvelele Nkuhlu Region Sato, Eastern Cape. Program Director, I'm going to reverse and park exactly where Comrade Sbeko is sitting. Comrade Sbeko, thank you. Mine is a comment. Comrade Sbeko, thank you ever so much for giving us as women assurance and certainty that we still have a second layer of leadership in our lifetime. Thank you. Thank you for rising and be counted that we are still relevant as women. And the little activities that we are doing in our little corners do drive the economy home. And I just want to land by saying, thank you for not disappointing Antonio Gramsci in his theory of cultural hegemony when he talks of organic intellectuals. Organic intellectuals lead society. They move society from what is wrong and nudge society to what is right and good. Thank you for proving beyond reasonable doubt that you are the intelligentsia, the advanced detachment of the working class. I know that you have little time, you are so busy, but please widen your scope and touch as many lives as far as possible. Just keep on keeping on, girl. Thank you.
Thank you very much. Thank you very much. And also on that note of organic intellectuals, I'm taken to a time of one of my previous bosses as well, who was very passionate about that point. But I'm telling you, I'm getting goosebumps just by listening to you right now, making that comment. Let's move it again. Okay, there's another one I'm going to take. Oh, there's one here at the front. And then we'll take it back to the back there. Yes, we'll come back. Yes, sir, please go ahead. Just short and sharp, please.
Sure. Thanks. My name is Tando Kotoe from the Nelson Mandela University. Mine is directed at Paul to say you've indicated the importance of these amendments, the Pillar Act. Now we operate in a climate of budgetary constraints and austerity measures. To what extent will those austerity measures impact on the effectiveness of those amendments? And particularly, you've interacted with the financial role players there. Section 237 of the Constitution says all constitutional obligations must be performed diligently and without delay. Then Section 28, subsection 2 of the Constitution says, in any matter that concerns a child, the best interests of the child are of paramount importance. So with these austerity measures, do you think they take into account those two constitutional provisions, that constitutional obligations must be performed diligently without delay, and also the best interest of the child? Thanks.
Thank you. So we're going to do the first round. If I can ask you, my esteemed panelists, to be short and sharp, because we need to go back for another round. All right, maybe we'll start with you, Mr. Sawa. Yes, go ahead.
Good, wait. Thank you very much for the question. First of all, I think that is what we're grappling with in education, and that is what this bill was all about, is to say, let's get it as quick as possible into action. And that's where the debate is now currently regarding the regulations for admissions and capacity, as well as languages. And I think we have not thought it through carefully in regards with it is immediately to be applied immediately. That, of course, puts a huge burden on the Department of Education regarding austerity measures, etc., etc. I think we can circumvent that by two things. First of all, number one, saying there is an actual plan for the next 3-4 years to be able to make sure that the implementation of the bill is really getting to the learner on the ground. And I think that is a way of changing it. And if we can get that narrative out there, that there is a constructive plan ahead to be able to integrate, especially grade R, which I think is the most important one. If we can do that, I think there will become a little bit of more restfulness within the communities in handling this. Because we have people out there that can take the department now to court, and it's been said also by the minister that they are open for that. But I also think we've got an understanding in our country of this cannot be done immediately, but we cannot handle it for the next 10 years and be at the same position that we are currently.
All right, Prof?
Yeah, so in theory, the Constitution and the rules of standing are very open to any group, including vulnerable groups, coming to court. In practice, vulnerable groups will only get to court if they can find a lawyer. And while there are social justice organizations that cover a range of issues, they don't cover the country geographically. So urban, Gauteng, Western Cape, Durban, rather than the rest of the country. So yes, there are huge practical problems of access. And then, even if you go to court on a socio-economic right, will you get a judgment and will that judgment be enforced? At the Center for Applied Legal Studies at WITS, we have a community that probably has 5 or 6 orders for the local municipality to deliver them water over 3 or 4 years, and they still don't have water. So there are all kinds of steps that make it really difficult.
Go ahead.
So in terms of spatial planning reforms, I definitely think, when you think about an economy, what are the needs? Why is it that some townships don't have bakeries? We eat bread every day, right? So if we meaningfully designed our communities, and especially taking into account climate change these days, right? So we don't want to be moving bread from Sentin to Tembisa. We think about the pollution that happens. I think there's a way in which I've played with this idea of what if we designed our economy around rights? We have a right to food, so how do we make sure food is produced locally? We have the right to education, how do we make sure there's good schools locally? Health, all those rights. Like if we thought about it that way, almost like a human rights-based economy is an idea I've thought about, not fully. And all those systems, how do we design those systems and integrate it? One, it would create jobs, right? Healthcare is not just about doctors on the front line, it's also about medicine manufacturing, it's about all these other inputs that are needed. And you could design localized economies that are self-sufficient, especially since COVID. We learned during COVID that when things shut down, how vulnerable are we in our communities? So I think we, as a society or societies, we need to start thinking about how do we produce localized in a way? So I think it's one way, and also land is a big part. So usually when people talk about spatial planning, they're talking about smart cities and big, beautiful buildings, but also where do people live, I think is an important part. Thank you for your very kind words. I was really close to tears. And I want to say that women actually do, estimates say that women do 30% of GDP of household work. So if we're to put estimates to it, you pay your helper at home X amount per day. The amount women do when we add all those numbers up, and it's called, you kind of substitute the work, taking care of a child, creche, whatever it is. And people have come up with these numbers that show that women are doing incredible work. A third of our GDP really is household production, which is not valued really ever. And then I think I also want to jump on the last question about the Bella and so forth. To say that, when South Africa appeared before the International Covenant on Economic, Social and Cultural Rights, they said that the right to education in South Africa, they were worried about austerity, and their suggestion was that the right to education in South Africa could be immediately realized. So not progressively. So for health, they said, okay, progressively. But they said, given the finances we have and the resources we have, we can actually immediately realize the right to education. And I think with Grade R, what the issue is that we've had a creche system that is privatized and subsidized by the state. Now you're trying to merge a privatized, subsidized system with a public system. And of course, unless if you're going to build creches in every single public school ever in South Africa, you're still going to have this conflict, right? And most people can't afford to send their children even to creches and so forth. So we're going to have a huge, I think, my projection is in the couple of years, we're going to have a huge dropout of children who aren't able to get into grade 1 because we just haven't created the supply for the grade R system itself. And I think the ECD sector itself needs reform because I think once we realize that childcare isn't a given, that women aren't always going to take care of children, or find other ways of providing it as a public good, not as a privatized good. I think that's the broader conversation for me about the grade R reform.
And just a quick one on ideally, what would that reform look like?
Public creches, free creches, no-fee creches, like how we have no-fee schools, right?
Childcare is a public
and
good.
creating that structure. Because also, I think the big hindrance is like,
Yeah.
that we hear. We used to have a time use survey in South Africa. We've had it 2000, 2010. We haven't had any more because Stats SA isn't getting enough money, unfortunately. But the time use survey, what it showed is that women, again, were saying, we can't find jobs because we're taking care of people. So if we want more women in the labor force, and I'm not saying more women should be in the labor force because capitalism is what it is, but to say that we have to create structures of care that take care of everyone from birth to death. Right? So elderly, like we've got an aging population. Who's going to take care of those elderly people? I don't think we've thought enough about care economies in South Africa.
All right, let's bring it back to the floor. Okay. All right, go ahead.
Thank you so much, Lovika Matthews from Naptosa, CTU, ATU. So my comment is directed at Mr. Lux Kabjana. Thank you for the presentation titled Diary of Sexual Harassment. While I appreciate the effort to tackle such a sensitive and urgent issue, I am concerned about the framing, particularly from what came across as a perpetrator's lens. Risk minimizing the lives, the lived realities of survivors, and instead focusing on the call for social justice of the hungry families of those found guilty. By questioning the definition of sexual harassment without clearly grounding it in existing legal and policy frameworks, the presentation may unintentionally create space for justifying harmful behaviors. It is important to remember that definitions are not merely academic. They exist to protect the rights, dignity, and safety of individuals, especially in workplaces and educational institutions.
All right.
Going forward, I'm almost done. Going forward, I would encourage ensuring that such discussions are rooted in recognizing definitions like that found in the Code of Good Practice on sexual harassment and mindful of the potential impact on audiences who may have experienced harassment themselves.
Sure.
Thank you.
All right. Thank you so much. We're very pressed for time. Thank you very much for that. And part of us having these conversations as well is that we're able to engage in them robustly so as well as critique them. Let's bring it back to the floor and, okay, I'm going to focus at the back because they feel neglected. Go ahead.
Yeah,
Go
thank you, sir. I'm very liking that you can see us. My name is Luzuko Puku from the TVET CGC. It's going to be a quick one. It's for the second and third speakers. I'm trying to get those presentations into a conversation in a way. Because I'm trying to understand the impact of the Constitution in reinforcing inequality in our country. Noting the fact that our history, the presenter presented about the Constitution, the history, and so the Constitution.
Oh, yeah.
But Section 25, there is the property rights, which in a way reinforces inequality. So I'm trying to ask to Ms. Beko and to the second presenter, what is the way of going around this? There are, of course, discussions around changing the Constitution. What is the way of going around this in order to ensure that our Constitution, in a way, does eventually fight inequality in our country? Thanks.
Sure. All right. Thank you.
Yeah.
There's another hand here. Okay. Let's bring it here to the front. Short and sharp, sir.
Yeah, very short. Can you hear me? Yeah.
Yes, yes, you're
Okay,
audible.
thank you. I'm Arjan van der Walt, also from Nelson Mandela University. Well, not quite. I retired in December. It's for Professor Albertine. Professor, I found it interesting. The one comment you made was that formal equality and substantive equality in our history has really been parallel. It's operating parallel, and there should be perhaps a meeting of pathways. Now, keeping that in mind, I want to ask, in substantive equality, it appears that it's group-based. So what I wanted to find out, is it not possible? Is it not possible in the development of our equality law to bring in an element perhaps of formal equality into the substantive equality by suggesting that a group of, and I'm referring specifically to employment discrimination cases, where if the justification is group-based, say for instance males or race, that there could be a test that the particular person who benefited because of the affirmative action is not disadvantaged any longer. Pretty much like the creamy layer type of concept in India. Do you think there's any scope for the development of that? Because that would mean that persons who are still disadvantaged would be protected, and persons who are not disadvantaged anymore would not get the benefit of affirmative action. Thank you.
All right, thank you so much. There's another hand there at the back. We'll come back to you. Just a quick one, please.
Quick. No, my question is just a very simple one. At some point, whilst we were fighting for liberation, some of our leaders would speak of a mixed economy. And I'm not sure whether they were looking at an economy that will reconcile all ideological influences, or an economy that will be practical to the challenges of the country. I'm looking at your presentation, Ms. Beko. It premised on the disadvantages of a capitalist society and how sometimes it may defeat the very desire for a country to self-sustain and also develop. So I just want you to comment on that, whether the notion of a mixed economy could be the real solution to our problems today, you know, without necessarily emphasizing on any ideological inclination. I'm just throwing that question to you.
Okay.
The last question would be to all of you. If education is to be bettered, what are the key things that you would advise government to focus on? Because we seem to be up and down on issues of education, but it looks like we lack focus with a view to improve. What are the few things that you can suggest to government? Thank you very much.
We'll come back for the final round, and I've noted the hands, 2 there at the back, and there's 2 there, and then the rest of it will take it. Okay, 1 here as well. We'll come back for the final round, but yes, go ahead. I'll start with you, Mr. Beck.
No, I'll just say the quick question about how to think about the constitution and budgets. I think the thing is, the question is, do our budgets meet our constitutional needs? And some of the questions when I was in civil society, we used to say is, have we ever costed what a human rights budget, as in if we could provide everything today? Have we ever even costed it? And we haven't. We actually don't know what the cost of provisioning all the constitutional rights today would be. And so the question is, what are we working towards? And I think really it's up to civil society, you guys, to ask National Treasury, how is this budget constitutional? How is it responding meaningfully in a way to progressively realizing rights? How is it, and I don't have the legal language, I wish I knew the law stuff, but you know, those are some of the things that we need to question. And I think already professors highlighted is that sometimes you get a court winning, but then the Constitutional Court will tell you that they can't force the executive to budget for that thing. So then there's also that conflict around the spheres of government, which I think needs a broader discussion. And I think in the question, in terms of mixed economy, I think we are in a mixed economy. I would usually describe South Africa as a neoliberal capitalist with some socialist values. We are already in a mixed economy. So to me, if you have a mixed economy, you're going to have mixed results, which is why in some areas we've got great progress and in others we don't. So I mean, I think ideological clarity is important. If we decide that on a principle, education is a public good, such and such is a public good, then there's ideological clarity, right? But now we're sitting in this place where it's like, yeah, we're okay with more private sector, we want more private sector, but we also want to provision. So I think what really would work for South Africa is we almost need to go back and rethink what is our ideological premise. If we want to use the Constitution as an ideological premise, that's fine. But we have to collectively get to a point of how do we design our economy, and not path dependent. And last point I want to make is that a lot of the policies we've implemented are not for an emerging economy, they're for a stabilized economy, right? Stabilization is implemented when you've already developed. You don't stabilize the interest rate when you're still developing. You know, so a lot of the policies we've been implementing are assuming that we're already there and we're not. Right. So we need to go back to what is a developmental state, what does an emerging state do to provide and grow and develop?
Prof?
Yeah, so land. So, of course, you can change the Constitution, you just need to get the numbers to do so. So the Constitution is no panacea, it can be changed tomorrow. The whole Constitution can be changed with different levels. So there's nothing stopping one doing that. I'm not a land lawyer. The person I follow on land is Tembeke Ngukatovi, who will argue very strongly that Section 25 is not a barrier, that in fact the way that it's being implemented is the real barrier in relation to land. But that's, I think, a debate that land lawyers are having. And there are people on both sides, and they're very progressive people on both sides. But certainly the Constitution is you know, it's not a little book that sits up there and no one can touch it, not at all. Yep, and then, so I mean, I would be very hesitant of the fact that the individual themselves, you know, it comes across as not supporting policies that are important. So there's a lot of debate around BEE at the moment, and there's no question that BEE has its problems. But the point is that ownership and control of the economy is skewed. So some kind of measure to redress that is important, and you can't say, oh, well, you can't just benefit the elite and not worry about I mean, obviously you have to worry about everybody. But I think so I think you have to think in a nuanced way about multiple positive measures that target different sectors of the economy and work out whether they are still needed, not by looking at the fact that the individual went to St. John's, but whether the group is sufficiently represented in the workplace. I do think employers should be more intersectional, though. So I do think employers should be thinking about diversity within race and within gender in ways that they're probably not doing sufficiently now. So don't always employ the person from St. John's, employ the person from a good township school, because that person doesn't necessarily have the same resources. So employers can do a lot, actually, to prevent a creamy layer without the law changing at all.
Yeah, and also on that, Mr. Kubjani, there was another comment on the floor with regards to the presentation in terms of some of the wording as well. I'm also keen on getting your response to that.
Yeah. Yeah. When I get an invite, actually, it was an invite based on the article that I've already wrote. You see, most of the things that I was saying, they were based on that particular article. But and again, I hear you and I acknowledge what you're saying, but I still maintain that, okay, for starters, I believe, I mean, everyone, including myself in here, we don't like the picture as it is today. We don't want sexual harassment. There's nobody who wants that. So I'm dealing much on the problem than to say it happened, it didn't happen. Hence I'm saying to you, I've read many cases. At some point I feel like I'm crazy because in one case, there was a hug. They say it's sexual harassment. In another case, there was a hug. It's not. That's what I'm saying. Let's work on the definition. Let's find something wherein, I mean, at least, I mean, it's like you look at the scenario and then you look at the elements in that scenario and say, no, it happened. Than when you just give somebody there to say, sit over here, this is a scenario, but the definition is not clear. So eventually, I mean, it's going to be how that particular person, I mean, have woken up on that particular day. If you woke up happy, it's going to say it happened. If you see, But if you have a clear guideline, then you'll be able to pinpoint. The same as we have with MEDA. I give you an example with MEDA. To say, with MEDA, you are able to go in there and say, okay, there was intention, it's unlawful, and all of that. That is,
All right.
yeah,
Okay.
the line along which I'm not.
Let's move it back to the floor. Is there, yes, go ahead.
Yeah, thank you so much, Ms. Lisiba Tobachal. I want to firstly appreciate all the presentations that were done, but my comment and question will be directed to Ms. Sibeko. You touched on unemployment. I mean, it's a very painful thing that we come across as a country when SAPS advertised 5,500 posts. There's over 1 million young people who clearly applied, and definitely most of them won't be considered. So the question that I want to put through is on austerity, to say austerity has been justified as if it is the right policy to disadvantage different departments, being it teaching, being it in health, being it in the safety and security. Because my understanding is that for foreign investment to attract it, at least on safety and security, you need to make sure that that is quite guaranteed in a country. But when we look at the state of safety in a country, it's quite a problem. And during COVID, austerity policy was used, COVID was used to justify the aggravation on the cutting of different budgets across all departments. So the question that I would like to pose to yourself, ma'am, with your good presentation, which I clearly appreciate, is how do we get ourselves out of where we find ourselves, more especially when it comes to the austerity policy, so that we can drive the country in the right direction? It doesn't seem there's a political will. How do we do it with the current state? Thank you.
All right. Okay. Right here in front, yeah? Go ahead.
Thank you very much, Chairperson. Let me also appreciate the presentation that has been made. My question will also be directed to Ms. Bego. We appreciate your insightful presentation, ma'am, and indeed it shows and highlights some of the deep inequalities that are being observed on the ground in our societies, mainly emanating from uneven distribution of financial resources, as well as funding of the mandates that are in the Constitution. Evidently, the state of our schooling system is going down, it's worsening. Shortage of resources such as textbooks in schools has been observed. Delays in also the filling of vacancies. And recently there have been a report that was released or surfaced from the Northern Cape Department of Education revealing that in the first quarter of 2025, more than 40,000 learners have dropped out at grade 8 to 10. Now looking into this, and considering the impact of austerity measures, I wish to hear your comment around the state's ability to fulfill its mandate in terms of Section 7, subsection 2 of the Constitution, in terms of respecting, fulfilling the mandates in the Bill of Rights. Thank you very much.
I think we'd agree that you are in demand this morning.
Clearly you guys need more economists here.
Yeah.
I think the question about, how do we get out of this unemployment conundrum, there's a lot I could say about this. But some of the things for me, it's really the question of how do we get out of this austerity situation is one. I think we need to convince National Treasury that this is not the right thing to do, and that it's very harmful. And I think there's a lot of research, evidence-based, that says austerity is bad for growth, for women, for everyone, really. And I think it's really about, the question for me, we've been in a place where we don't have a good fiscal contract. We don't have we've got a fiscal contract problem, right? So, for example, in the recent budget, National Treasury is quick to say, let's increase VAT, which impacts all of us. But why are they so determined to not have a wealth tax? right? To me, the choices, why is it easy to say everybody can take the bullet, but we're not going to wealth tax the 2,800 people in South Africa who've each got more than 50 million rands in assets. There's 2,800 people in South Africa who've got over 50 million rand in assets and so forth. And not just that, they've also got over 400,000 or 400 billion in offshore assets. So to me, those 2,800 people, even if we tax them at 0.5%, we could have raised the same amount that we were going to get from VAT on the entire population of South Africa. So the fiscal legitimacy and contracts, how do we make decisions, is important. The question about can we, and of course jobs, there's a lot of other things, the ITUC, the International Trade Union, yeah, they also, C, I can't forget the C, I can't remember the C, but they were saying that, for example, if we just invested 2% of GDP on their care economies, we could actually create a lot of jobs, like just taking care of the elderly, the young, the so forth. So there is investment, and I think we need to get out of this idea that like when we spend on people, it's like a social spend versus economic spend, right? Spending on people, to me, is economic investment in the long run. So we need to get away from this dichotomy of like when we spend on certain sectors, it's not generating jobs, it's not being economically valuable and so forth. So that's part of the kind of, you know, or issues that we need to deal with in South Africa. And lastly, to say that one thing that the apartheid government, I hate to say that, but one thing the apartheid government did well is that the universities actually communicated with the sectors to say, this is what we need. So there was a clear pipeline from when you went to a TVET to a job. There was a very clear pipeline about what economy you're building and what skills are needed and more communication between the two. And I think what's happening now, obviously with AI and stuff, the economy is shifting. And I think we also need to come to the reality that not everybody's going to get a job, which is why I'm a big proponent of a basic income grant. With the world changing, technology changing, not all of us are going to be employed. I mean, I'm sure you could Google, get AI to write your paper about economics, and then you might not need me here because AI will give you an essay about unemployment or whatever. So we also have to deal with that reality that some of our jobs are going to be obsolete. And then the question on the backlog, I think there's a lot of infrastructure backlogs in health, and I think part of the issue is who provides some of the infrastructure. It's not always DBE that's in charge of certain elements, right? So infrastructure is not a DBE function. And I think one of the things we need to think about is across mandates, how we managing demands and so forth. I think we can definitely afford education. I mean, any country can afford education. It's about whether do you want to or not. What are you willing to do? Last year, we were willing to basically take out 100 billion from the GFECRA, from the gold reserves. Where did that come from? It's a new thing, right? We can do it. Again, we can. There's space. It's a question of, are we willing to look at the alternatives, wealth taxes, climate taxes? We can think of all sorts of things to think about how to finance our development. You know, we are our own sovereign state with our own currency. I just feel like we're just not, well, let me say not we, but I think government is not willing to always explore alternatives in a meaningful way to actually change the situation, and it's easier to stay in the status quo.
All right, let's take it to the back there. Go ahead.
Thank you, Chairperson of the proceedings, and good afternoon to the panelists. Chair one, I think I am Koya from the Eastern Cape. First, I think let's welcome the presentations. They are just quite important and imperative, as well as giving a lot of insight into what we are here for today. Let me firstly make a statement which can be buttressed, by the way, that first and foremost, as a country, we have the best constitution in the world. Number two, Chair, I think it's also a statement that whilst we're talking of a mixed economy, the reality and the truth of the matter is that the dominant character of the South African economy is not a mixed economy. It is a capitalistic mode of production. Hence the challenges as outlined by many of you. Critically, my question then arises to say, how can we be able to ensure that the law is able to work for each citizen in the true sense of redress and equality? I'm raising this matter because in the application of the law, what then becomes the glaring challenge? We are not equal. It depends on the corner, where are you? Those who are well-to-do and affluent, they are able to run away and succeed. And those who belong to the doldrums are indeed affected by the effect of the law.
All right.
Much of the time we speak around the equality, but there is very low sense in terms of how do you redress the past imbalances so that when you allow these kids to compete on an equal basis, you have made sure that the seeds have been planted to make sure that that competition or equal opportunities has been planted.
All right. And
thank you.
All right. And I'm going to ask that you be crisp and sharp because I want us to get through as many points from the floor as possible. We'll bring it here to the front. Yes. Go ahead.
Thank you. Let me get right to the question. I had hoped that Mr. Lux would have responded to the Section 28 assertion that was made by Mr. Kotoi in terms of the industry that we operate in. But let me just clarify one thing. There is a definition in the code. We might not like it, but it exists. Mr. Lux, just for completion, it's defined, sexual harassment is defined as unwanted conduct of a sexual nature. The unwanted nature of sexual harassment distinguishes it from behavior that is welcome and mutual. It goes on to further define, and I'm sure by virtue of the fact that you are a senior lecturer, you would know. I think it's important that we teach people not to go around hugging people and depend on how they receive information. They receive those hugs and say they woke up on the right side of the bed or the wrong side of the bed. I think we're trivializing the challenges that we face. And I'll leave it at that. Madam Sbeko, I think perhaps let me just start somewhere. I found what I was looking for. I'm sure you would be aware that the South African Human Rights Commission, in fact, called for a human rights centric and pro-poor budget for 2025. But I suppose that even with your own children, that you can only give them based on what you have and not necessarily what they need. And I'm saying need, not want. And so whenever we talk about what the state must do, we must also be considerate of those resources that come from our taxes. So whenever we talk about free, we must evaluate that against what is in existence. And in this statement, which was on the 19th of February this year, the South African Human Rights Commission is well aware, because when they ask for this budget, they talk about prioritizing education and health and so forth within the limited need, within the limited resources that exist in the country. So we must always have at the back of our minds that whenever we want more, we mean increase in taxes. And part of the question that we must ask is whether we can afford that. Thank you.
All right. Do you have any more hands from the floor? Oh yeah, there's one here. Thank you. Sure, go ahead.
Ke a leboha motsamaiso wa mosebetsi. Ke Mr. Sabata from NATU. Then, you know, the presentation of Ms. Sibeko made a tremendous pour her to such an extent I feel temperamental where I'm sitting. Because of the following measure of knowledge.
Raise your mic for me, thank you.
Because of the following measure of knowledge. Then the first one, in 2024, over 1,500 businesses were liquidated in South Africa. From January to June 2025, 700 businesses were liquidated in South Africa. And only in June, 150 businesses were liquidated. And for the government to have revenue, it generates its revenue through taxation, including what? Including income tax, company tax, and sales tax. If we take the measures that I've just tendered, what will be the impact of those measures on unemployment, poverty, and inequality, not forgetting the government spending? Thank you.
Thank you very much. Do we have more hands from the floor? Go ahead.
Thank you very much, Madam Director. My name is Bongani Henry Ndlovu from the National Teachers Union. My question is directed to Mr. Lux. Profiling sexual offenders and putting them on the register, is it helping to fight the recidivism rate in South Africa? Meaning that, does it fight that the sexual offenders do not repeat the same act again? The second question is directed to Mrs. Bego. Thank you very much for a profound presentation. Raising taxes takes money out of the economy, stifling growth and economic development. It also erodes the tax base, which is the goose that provide eggs. Do you think raising tax is a good move for the South African government? Thank you.
All right, do we have any more hands from the floor? Yes, no, maybe? Okay. All right. Over to you.
Hey, I'm in an exam today. Thank you all for the very good questions. I think, you know, the issue of human rights and whatever we call it, gender responsive budgeting, human rights budgeting, we've had many tools and they exist, they're tools and you can learn how to look at a budget and analyze it from a particular angle. And I think, again, it's a question, the National Treasury is currently trying to reintroduce gender responsive budgeting. It's still in its pilot phase. I've actually already written a paper to critique the process because I don't think expenditure tagging, so what they're trying to do is basically say, out of this 1 billion that we spent on education, we estimate that 40% was for women, which I don't think is helpful. Because for a lot of the expenditure, government expenditure, 99% of it, we actually can't tell the gendered impact. If you build a road, is it for women or men? We don't know. So a lot of your expenditure is going to end up in the general category of expenditure. So I don't think the way they want to do gender responsive budgeting is going to actually change fundamentally stuff in South Africa. And gender responsive budgeting aren't budgets for women. You know, and I think that's where we're getting what gender responsive budgeting fundamentally is wrong. So the questions, I'm going to group the questions on taxes and stuff first. So my first thing is that a national budget is not like a household budget. Let's start there. So we can't use the same logics of I've got X amount, therefore I spend X amount, right? And I was trying to hear, well, the internet is not allowing me to find this article. But really to say that I've written an article about why there's a difference between a national budget and a household budget. The first is that in your house, you can't print money. You can't directly control the supply and demand of currency in the economy. That's a major difference, right? So once we start applying household logic to state logic, that's when we end up being like, there's no money. There was that comment about what your household, what your children need versus what you can do. A state can do as much as they want to do. The question is, are you willing to do it? And I think the question about, you know, our revenue, there's a big debate in economics, which is, does the state spend first and recuperate that money through tax? Right? Think about it. The budget happens when? In February. When do we know the outcomes of our tax? When do you file your taxes? The following year, right? So at the point where we're estimating what the state is going to get, we've already decided we're going to spend the money. And we've given the departments the money. And when do we get the tax? Later on. And then the other debate is, do we tax first and then spend? So that's a whole economics debate. I'd argue that government spends first and then we tax after, which is why you get your departmental budget in April. But the financial year taxes are only going to happen next year for this current year. So we mustn't think in this way that we can only spend what we have in revenue, but also that means we're not counting into account or taking into account what the South African Reserve Bank can do for the state, which comes to the question of businesses. The South African Reserve Bank can make credit available to businesses. If we decide that we want to expand certain sectors, we can make credit available to keep businesses alive, and those businesses employ people. So what I'm really trying to get to is to say, government spending is regenerative. So if we think in the sense that once money is spent, it's gone, it's finished. We don't consider how that 350 you gave somebody, how they went to buy at ShopRite, how ShopRite then was able to pay more taxes to government because this person was able to, so it's money moves, right? And a lot of people will, and even that 350, 16% of it came back to government as what? As VAT. Right, so money moves in ways that are beyond even our own understanding, and it's regenerative in that way. It came back in somebody feeding their child who won't need long-term care because they're going to be healthy, they won't be stunted, they're not going to come back to the healthcare system 15 years from now with all these issues. Now we have to address fiscal issues later on. So I think we need to also, and that's a big, I mean, that's a whole lesson. I don't want to go on and on about it, but really to say that that is the fundamental place we have to think from, which is that the state's resources are not as limited as we believe. And once we begin believing the state's resources are limited, this is when we start kind of like pitting rights against each other. Right? That's when we start pitting rights. Instead of saying, and this is the question I ask myself, can we afford not to provision? Can we afford not to? At the end of the day. And how do you provision? I think a lot of our answers are, we can't afford it, where will we get the money? No, it's how can we provision? And if we start questioning that, then we can generate alternatives. And I think raising taxes isn't inherently bad. So it depends, is it a progressive tax or is it a regressive tax? VAT would have actually impacted our economy more negatively than implementing a wealth tax. And we've modeled this where I work, which I shall not mention, but we've modeled this wealth tax versus VAT and so forth. So people are doing the work to show that, in fact, a wealth tax is not going to inherently mean people are going to run away. If your mine is in South Africa, if your mine is here, and you get gold in South Africa, where else are you going to get gold? Are you going to move your whole mine tomorrow? That's not how wealth works. A lot of the wealth people are getting, especially minerals, you can't just move to another country tomorrow. You're not going to get that wealth there. And the studies also show that companies can already reduce their tax liability anyway. They can plan tax away anyway. So even if the statutory rate was 50%, they're going to pay what they want based on who can help them maneuver through the tax system anyway. They're already not paying their fair share anyway. So that's my sense on taxes, that a lot of businesses don't pay their fair share, and especially a lot of wealthy people don't pay their fair share. The average person in South Africa pays their fair share.
Right.
Yeah.
Mr. Sal, we're wrapping it up. Let's get your closing thoughts on this one.
I'd just like to say thank you for the comment. What are the three things I would do?
Yeah, let's just get your wrap-up thoughts.
I think the most important way that we need to look at is to be sure that the money that we do have, we use it wisely and we use it to the bare basics that we actually need to implement and to make sure that that is a progressive trend throughout. We are in this conundrum of austerity and unemployment, but we also need to realize that we've been that for quite a while now, and we needed to be able to adapt to it. And I think our economic and departments didn't adapt sufficiently in regards to that specific area that we need to look at.
Prof?
Yeah, so the million-dollar question, how do we make equality work? It's so complex. I mean, I would say 4 things, and they're all big. I would say get democratic politics right in this country so people's representatives are actually putting in place the right social and economic choices for the majority of people who are poor and unequal. I know that's a very big ask, but that's, I think, fundamental. Get the education and health systems working, but maybe more practically, your opportunity should never depend on the patronage networks to whom you may or may not belong. So if you can break patronage networks, then opportunities are freer. I mean, earlier on somebody was talking about selling jobs, right? I mean, it's breaking those kinds of networks to open up opportunities for everybody who qualifies in fair ways. That seems to be quite a practical, easy starting point, at least to spread things more widely.
All right, Mr. Gupjana, let's get your closing remarks. Yeah, it's been a very interesting morning. We'll take it offline nonetheless. But we thank you so much. Ladies and gentlemen, please a resounding applause for my panelists for this session. I was so engaged. We had a very good one. I must thank you so much for all your contributions. And before we break, ladies and gentlemen, just a couple of notices. I'm told that the gala event will be tomorrow because some had already thought it was today. No, it is happening tomorrow. So that's on that one. And also to ask you guys to also scan the barcodes at the Juta stand because that will also put you in line to win prizes at tomorrow's raffle. But also these presentations will be available on the ELRC website straight after the session. So you can go there and read them again and go through them again, just if you have a sense of nostalgia again. But also another one for the Department of Basic Education, the Employer Caucus has been asked to gather here by the stairs as we break for tea break. This is in front of the stairs for them to take a photo with the birthday boy, Mr. Faker. And this happens straight after this. But otherwise, please stand by to receive your gifts. Thank you so much for your time. This was robust. Thank you so much. Round of applause again. We are now getting into the second session for the day as we continue with conversations. And I'd like to call upon Professor Collier from the University of the Western Cape to talk to us about labor law as a technology for humanizing work in the digital era, seeing that everything is moving into that space. Over to you, Prof.
Just a thank you to the ELRC office bearers for this opportunity, and especially to reflect on an aspect of adapting to the evolving labor landscape to promote social justice. And I'll do so in the context of information and communication technology, advanced technologies, 4IR technologies, artificial intelligence. All of these are impacting on our labor landscape. And so my argument about labor law is twofold. The first is that labor law remains, and it has been and it remains, an important tool for promoting social justice in the evolving world of work. But it does mean that to achieve its objectives, that labor law must also evolve and adapt to the changing world of work. And so what I want to do today, and my presentation is based on a chapter. I was approached to talk about a chapter that I had written and in fact the book is available. It's an open source book on artificial intelligence and the law in Africa. It's a LexisNexis publication from 2023, and it looks at a number of areas of law, including developments in legal ethics, intellectual property, as well as the impact in energy and mining, agriculture, and looking at digital provisions in terms of credit, and a number of important sectors where artificial intelligence is changing the world of work. And so my focus in the chapter was really on labor law and what's the future of labor law. And so in my presentation, I'll try to do three things. The first is just to provide a very high-level overview of the evolving world of work. So how is advanced technology and AI? What sort of impact is it having? And so you'll see from a slide that I'll get to from an ILO study, in many respects, education sector or the jobs of teachers is probably more stable than most. So one of the biggest fears, of course, is about what will our jobs look like. So those of us teaching the youth and the youth of the future, of course, have to take that into account. So which sectors will be most impacted in terms of job losses? And then, of course, our retrenchment law and as well as our skills development becomes critical. Or how will our work be restructured? And we've seen a move over the years, and it was accelerated really by the pandemic, where many workers are performing remote work, which is enabled, of course, by advanced technologies, and it is disruptive in terms of the kind of structures that we were accustomed to when we developed our labor law. So our labor law evolved from a particular model. Many of you, I'm sure, would have heard of the Ford factory model. We anticipate labor law being applicable in workplaces where workers are gathered and working in close proximity to each other. This enables collective bargaining and a particular approach to the employment relationship, which is disrupted by technology. We see this in platform work, the rise in the gig economy, and the Ubers of the world, and others. So I'll talk a little bit about that. But more importantly, for your own jobs that you perform, is the impact on the quality of jobs. AI has the ability to increase supervision. Workers are managed by technology. Technology can intrude on privacy. There's increased monitoring and surveillance. Decisions can be made by AI, and that can have negative consequences. And so that was really my theme in the book chapter, was to use labor law to ensure that labor law developed as a technology for humanizing work. So I will have a little bit more of a look. Let me move on. I'm going to watch my time carefully, and perhaps I'll move back to that. But the chapter deals with the impact of AI on work in the context of the African continent more generally. So we've had a lot of conversation about the informal, or what we call the informal, or urban informal economies. And what we need to realize when we look at labor law is how it actually has developed historically to protect a small minority of workers. So we talk about high levels of unemployment, and they are persistent. But there are many workers who are performing work in multiple ways and contributing to the economy, as we've heard, who are not protected by labor law. So labor law itself is exclusionary. It excludes many workers, and the introduction of technology brings with it the potential for more people. Our AI strategy, or a draft AI strategy in South Africa, talks about providing support for workers as they transition into informal modes of work. So we recognize the NEPAD AI policy recognizes that people will no longer aspire to jobs, but will aspire to work. And we need to recognize this. So what does that mean for us as labor lawyers really is part of the focus of the book chapter. And then lastly, I'll just identify what needs to happen if our labor law is to evolve to become a technology for humanizing work in the digital era. So the slide that's on now is just the study by the ILO, and I've just extracted the part I need bifocals. I just extracted the part about the education sector. And so what the methodology of the study was to take the international occupational standards categorization and to actually ask ChatGPT, which So the ILO has methodically categorized the different tasks of each occupation. And then ChatGPT was asked, which part of these jobs can you perform? In other words, can we replace a human with you? And they wrote up the study. And you'll see here, teaching is the one profession where in particular, ChatGPT says that there are things that it can't do. So it can assist with generating lessons plan and offer suggestions, but that a human is needed to obtain a nuanced understanding of students' needs, which will be important for crafting the plans themselves. And in terms of implementation, there needs to be implementation of education, particularly at primary levels. There needs to be a physical presence, there needs to be an emotional connection, and a real-time adaptability of a human teacher. So it is a profession that is secured, and the role may be augmented by technology, but not replaced. However, there are other occupations where jobs will no longer exist because of advanced technology. So again, AI technology can assist in monitoring, providing feedback, but it cannot fully automate the classroom environment and discipline. So I'm going to go back just to perhaps give a little bit of a context also about the African continent, because there's a significant push for regional integration, the African Continental Free Trade Area, and AI is regulated at the AU level in an effort to develop standards, ethical guidelines for AI, which will impact on us and should do so. So we're not working in isolation. Obviously, globalization is accelerated by advanced technology, and so our standards will also be drawn from the regional and AU context. But in terms of our population, we do have a demographic dividend. Most of the Western Europe countries and Japan, the US have their age pyramid is heavier on the top. They have more aging population. Africa is the opposite. Our triangle is inverted. We have youth. And so the education of youth in terms of being able to take advantage of the opportunities that AI and advanced technologies introduces is significant. And that is recognized in these AI policies and technology policies in the AU context. But of course, if we don't get it right, it's a missed opportunity. So there are challenges as well as opportunities. And then I've mentioned the extent to which the population, particularly across the continent, is involved in South Africa. We know the formal economy is larger than in most African countries, but on the African continent, 85% of workers in the SADC region and the sub-Saharan region are employed in the informal economy. So that means 15% of workers will be protected by labor law. And the question becomes, how do we roll out labor rights for workers who are not in the formal economy? Because the message really from the AU documents and from the South African strategies is that, in fact, we should be focusing on, and from our economists as well, that we should be looking at strengthening informal economies and communities and work that is performed outside of the formal. Informal is an unfortunate Western ILO concept, but rather looking at our economy from a human rights perspective and looking at developing rights for workers outside of what we would term the formal economy. So just in terms of which sectors are most impacted, business activities in agriculture, drones for mining, applications in manufacturing and health, applications in energy, finance, education, transportation, and public service delivery are primarily, in most of those sectors, it is about augmenting the work that we do and changing the nature of the work that we do rather than replacing jobs, except for mining, where some automated functions may well replace workers. So new technologies are also, of course, changing the way that we structure work, and non-standard forms of work are on the increase, which has had a negative impact on trade union organizing. And if we recognize the importance of trade unions for our democracies, and trade unions for increasing and improving and promoting workers' rights, this is a challenge. Our labor law, I'm sure all of you will be familiar with the who is an employee question, and the extent to which that has limitations that will increasingly serve to exclude workers from labor protection. So I've mentioned earlier about the AU's artificial intelligence policies, which talk about work rather than jobs and focus on ensuring decent work for workers and rights for workers rather than jobs in the formal economy. And then let me move past this. This is just also, my slides will be uploaded, but just to indicate the types of jobs that are most likely going to be impacted more significantly than others. Clerical support workers have quite a high exposure to GPT functions. Again, not to suggest that these roles will necessarily be replaced, but their jobs will be augmented. In the labor studies of businesses, I think it's a World Economic Forum study, the companies who can replace workers with technology have indicated that it's not their desire to do so necessarily, but they will allow for a natural attrition. So jobs they will no longer be employing. So we'll see shrinking job forces within formal, and we see that, of course, even in the public sector in the States. So the positions that are most impacted are professionals. Of course, we've seen some horrific AI ethical issues in our courts, where cases are being fabricated and relied upon. So there's a lot of exposure in the professional, technical, and clerical support workers. And as we move into these semi-skilled sectors, agriculture, forestry, and fisheries, it's relatively limited, and there are a lot of opportunities for advanced technology to really assist with some of the challenges that we face. For example, in agriculture, being able to predict and deal with seasonal changes and deal with pests and diseases. We no longer have to expose workers. So a lot of the benefits are from an occupational health and safety perspective. Having said that, there are risks from an occupational health and safety perspective that I will get to in a minute. But so pesticides no longer have to be handled. There are drone services and a growing delivery of, and really very targeted. Our students certainly are using AI, and I think the ChatGPT 4 could pass a bachelor's degree. ChatGPT 5 apparently can pass a PhD if it's prompted properly. So it does mean those of us who are grading need to develop new standards and ways of assessing knowledge. So these are some of the, I mentioned earlier that the concerns are around both jobs being lost, and the types of jobs that our youth will be performing in 10 years' time differs from what we know our work today. But also concerns about the quality of work and the risk for technology to reduce workers' autonomy and discretion. In Cape Town, we've just opened an Amazon premises, or we're in the process of opening an Amazon. Amazon, some of us use a Fitbit to trace our steps, to assess our sleep. Amazon uses it to assess how many footsteps you take in a minute, how you toilet breaks, women who need additional time, it's all monitored. There's disciplinary measures, warnings, all based on a tracker, and decisions are taken that are automated. So that risk of workers' autonomy is very real. And there will be an increased speed and intensity of work, so the requirements for output and performance are likely to increase if technology is supposedly assisting in the performance of work, but much greater surveillance in general. So of course, this is where labor law is really important, to make sure that humans are not having decisions taken about their work by a machine, that there is human intervention, a human-centered approach. So the ethical principles to AI is that there must be human oversight. So it is also in the design of the AI itself, but once AI is deployed, there must be human review of any decision, as well as a right of appeal. And there must be full transparency. And this, again, is where trade unions can play an important role in the ethical rollout of technology in workplaces and management of technology. Okay, so I won't go through too much of this, but, just to say that some of you may have read in the media the case of the Kenyan content moderators, so the use of, again, we have a youth dividend, we have young, unemployed, talented individuals on the continent, and often are used to train AI systems, but also to moderate content. So the issue that arose in Kenya was content moderators being exposed to horrific, truly horrific content. So if anybody puts a flag, or if a flag and AI does some of this work, AI can say this is, an explicit image, but the content moderators in Kenya were exposed to the most egregious scenes of sexual violence, sexual assault, torture, war crimes, and again, in terms of the monitoring, and this is all for Facebook and Meta, in terms of the work relationship, which of course the labor lawyers would be keen to know about. So it's an outsourcing arrangement. Meta and Facebook would use an outsourcing company in Kenya and other countries. I think Ethiopia was another. And then workers would be recruited for the outsourcing companies. So these were not actually independent contractors. It's different. The Uber model of the gig economy is an independent contractor, but these are outsourcing arrangements. But the extent to which these workers were exposed to really graphic scenes of death and sexual violence and harassment resulted in high levels of PTSD, mental health issues, and there is a case pending, I think, before the USA to protect these workers. So our continent is, again, being used as a resource for work to be performed, and of course the role of labor law would be to ensure that the correct accountability standards are in place. A lot of these issues are before the ILO, and in June 2025, a new convention, I think we heard earlier Convention 190, the next convention is likely to be one for decent work in the gig economy or platform work. So many of these workers are classified as independent contractors, which means they lack rights and benefits. Okay, so just to talk a little bit about if we are going to to use the opportunities that are presented by advanced technologies, we of course need to do something to address the digital divide. In the African context, although access to connectivity, access to the internet has increased, so the coverage gap has shrunk, but the usage gap has grown, which means technology is not being used to the full extent that it could be. Some of this is related to cost, but also the absence of local content. So the fear also is that the technologies that we use will be imported technologies and not homegrown, and the content will not fit for local contexts. And then also cyber hygiene. So our next speaker will talk about cyber crimes and what is needed to encourage productive use of ICT technologies to ensure that we make good use of the opportunities. But we also, the thing with AI computing is the extent to which, so I think a percentage from the United Nations, the UNDP, is that only 5%, we have talented programmers, software developers, but only 5% of the designers and developers on the continent have access to the computational resources that they need. And unfortunately, you know, the data centers are massive. They have a huge demand for water. And so, you know, to develop the capacity and resources on the continent will be a significant undertaking. But it would be necessary if we are to take advantage and not to simply adopt from other countries. And then I've mentioned earlier the informal economy. We use the term. It's not ideal in my view, but it is a term that's used. And so I mentioned earlier that 95%, I think the statistics are on that slide, 83% of employment in Africa and 85% in sub-Saharan Africa is informal. And that, of course, is most of the youth employment seekers will not be finding jobs. They will be working in the informal economy. Of course, in theory, if you're in an employment relationship, labor law will protect you if you're in the informal economy. But the point about the informal economy is that the reach of labor law has not extended, and it's exclusionary. And those who have benefited from labor law are an increasingly small subset of workers. And so how do we deal with that? And this is the part really where I start talking about labor law. We also need to, yesterday we spoke about the importance of history. We need to think about where our labor law and where our legal systems in general have evolved and developed from. They have been influenced by our colonial powers, and they have been influenced in our industrialization processes, which were very limited. Industrialization on the continent was largely so that resources could be extracted. It wasn't a full industrial development that was taking place. And so there's uneven industrial development, which means labor law is servicing some, but not all workers. But on top of that, the work in the informal economy is largely subjected, although this is changing, but it's largely subjected to laws, colonial laws, which have been repealed in the colonies, but still exist in some African countries, that criminalizes work in the informal economy. So in essence, we criminalize poverty and being poor. Vagrancy laws, the inability to trade, access to land, property rights is incredibly important if we are going to secure and upgrade the rights of workers in the so-called informal economy. And that's a conundrum for labor law, because our labor law is designed around an employment relationship. Our resources, the CCMA, our bargaining councils are designed around an employment relationship and the capacity to develop and absorb workers who are not within those formal employment relationships is limited. We heard earlier from Prof. Albertine about using our Equality Act more creatively, and that is indeed where the case can be made for workers who are not employees to have access to the types of capacity and resources and bargaining forums which workers who are employees have. So there is also a fear that if we don't grasp this opportunity for what is termed by Barani as the algorithmic colonization of Africa, which may echo colonialism by neglecting local interests and disadvantaging minority groups, which again ratchets up the digital divide and inequality. Okay, so I think most of what is on the slide I have indicated. Of course, we've also heard earlier about climate change. This has a significant impact, and of course, it's not Africa who's contributing. South Africa is the biggest emitter on the continent, but most of the other African countries that are impacted by climate change are not the large emitters. So any development of labor law needs to also take account of migratory shifts that are likely to happen because of climate change, as well as the requirements for, earlier this year, our Climate Change Act was promulgated. We've seen carbon emission targets being set for some sectors. That really means that trade unions and workers need to be alert to what that means. What does it mean for jobs? Will jobs be lost? As we shift our energy system from coal, we are going to see energy distributed differently, and coal mining in most countries, in many countries, and the mining sector was really very critical to formalizing our trade union and strengthening the trade union movement. All of that comes under threat when we move into, unless we know about it and make steps to mitigate and ensure that our trade unions are mobilizing workers using technology who are not traditionally in the types of employment relationships that trade unions would ordinarily have recruited or organized. So we've seen also challenges before the Labor Court, Labor Appeal Court, the Simunya Workers Forum, the Uber case, where workers are asking for the rights to register trade unions, even though they're non-standard forms of work, and where workers are asking for classifications that would give them protection under the Labor Relations Act. And again, I mentioned earlier, we need to also look at developments on the continent and take into account those standards as we move forward. So this, and I'm sorry, I hope I'm not running out of time, but these are just what must our labor law do? What are the areas that we need to be mindful of in terms of humanizing work in a digital era? We need to revisit the roles, the values, and the boundaries of labor law. Labor lawyers would be very familiar with these arguments. And of course, we heard, I think yesterday, about Otto Kahn Freund, about labor law's role as balancing unequal power relationships. But more than that, we are now moving into an era of climate change. In fact, in education, you know, it's about developing standards also for extreme weather events, heat and heat tolerance, and so, and much more broadly in terms of sustainable development. Having conversations about what that means, even if our own workplaces are not impacted by the introduction of technology, we should also be moving to more resilient, climate change adaptation should be impacting on how we organize and should become a part of the functions of labor law. At least it's an argument that I make in the chapter. And then, again, shifting the boundaries and the debate on who is an employee and ensuring that all workers have access to the types of protections. Of course, it means different things depending on the type of work you are doing in the informal economy. And so, again, a human rights approach rather than an employment relationship and labor rights within an employment relationship needs to be taken into account there. And then responding to the potential displacement of jobs. Social dialogue, of course, remains important throughout all of these conversations, and particularly when there's going to be displacement or jobs that are augmented, job functions changing, it's critical that we do our skills development right. And so, you know, the SETAs, once we are in the higher education sector, we need to ensure that that conversation, it's not happening. It did used to happen in a better way around what occupations are going to be required in industries, those industry plans. Bargaining councils will play a critical role in those conversations as well. So it's not only about, and our retrenchment laws, of course, can also be adapted, or our collective agreements around, you know, some of the collective agreements on the adoption of climate change technologies. You know, they start from 5 years before retrenchment is contemplated, and the workers, the trade unions and employers will have agreements that talk about these are the job functions that will be impacted, and setting in place social security systems, setting in place skills development and training needs. All of that planning really needs to be happening if we're going to do this in a way that promotes social justice, both in the context of technology and climate change, because both will have significant impact in the medium term. And then just in terms of our own standard employment relationship context, it is our privacy really that is critical. It's algorithmic management and privacy, making sure that decisions are taken in a transparent way, making sure that our privacy and our data is the new gold. There are a lot of technologies in the West that are being developed on the back of data that is extracted from our continent. And so it is ensuring, not only in terms of our workplace relations, but in general, in terms of the value of data, and that data is not being extracted unfairly or sold or used unfairly. And ensuring against excessive surveillance and abusive supervision practices. It's easy in an employment relationship because that is what labor law does. It gives us the tools to fight back against managerial prerogative. But for workers in the gig economy, that is an absent right and something that we would need to address. And then, of course, humans have biases. We all have our built-in, you know, we make quick decisions about people and about things based on our inherent biases. And we have tools to address discrimination. We've heard about them earlier. But AI is programmed by a human. So whatever the follies of that human was, AI then replicates that on, you know, in an accelerated, at-scale way. So it really it is something that needs to be taken seriously. And then finally, as I mentioned, reaffirming and revitalizing workers' collective rights. It's really critical that we don't, you know, although social dialogue happens at sectoral level in some sectors and industries like this, but we don't have workplace forums. We don't have those you know, those really critical discussions at enterprise level. We bargain, yes, but that's distributive, and it's not about the social aspects. And so we really need to think about: are we doing ourselves a disservice in terms of the way that we've structured our social dialogue relationships and forums. And I think that is, I really won't repeat anything that I've said. I'm conscious of time. Again, labor law should not be seen in abstract. It cannot solve all of these problems. It's a paper tiger, you know, fierce in appearance, but with very little teeth or claws, unless we actually have the capacity and resources and the worker representatives. So we really need to have a whole of government, whole of policy approach, and look at it also from a skills development and labor market policies. Things like the basic income grant, but also rolling out social protection to workers who are not informal employment relationships, and ways of doing that need to be looked at. And I think I shall stop there. Thank you for listening. Thank you.
Ladies and gentlemen, would now like to call upon Professor S. Kamtuze, who's Director at Snail Attorneys at Law, to talk to us about cybercrime law in South Africa. Round of applause, please.
I'm here to talk about cybercrime today. Maybe some of you have seen me in the past. I've done a lot of work in terms of cyber law, ICTs, data protection. Maybe once upon a time you saw me on TV with the information regulator many years ago. But today I've been asked to talk about cybercrimes. The attempt will be not to lecture. That will be the attempt. However, the topic is a little bit rich, so I will allow you to follow on the screens. The slides are quite, should I say, substantive. So I will talk in between. Don't mind if everything doesn't tally at the time. Okay, so cybercrimes. Where do we get cybercrime law in terms of our jurisprudence? Everything started in a town called Budapest, right? Everything started in a town called Budapest, and the Council of Europe, as they are called, not the EU, the Council of Europe, two different bodies. The Council of Europe, some 30 odd years ago, met in Budapest and they drafted the Budapest Convention. The reason why this convention needed to be drafted was because the internet had come. We had our UNICITRAL model laws dealing with e-commerce, dealing with e-signatures, and with everything that is beautiful, obviously criminality started cropping up as well. Back in the days, we all used to talk about 419 scams, right? And there was this hostility around Nigerian 419 scammers, right? Let me tell you something. The biggest cyber criminals are now here in South Africa, right? We're not just tops with hijacking and tops with murder, but we're also tops with cyber criminality. I know it's very dry humor, but that is the current state of affairs. Now, the Council of Europe came up with a model law, and this model law has been used basically as international best practice. I'm trying to run away to say that it's international law, because it's not. But because so many people have adopted the Budapest Convention, I refer to it as international best practice. Now, the Budapest Convention basically created laws against illegal access, what we commonly call hacking and cracking, okay? Illegal interception, in other words, people who would go and intercept your emails. I'm sure we've all been hearing about business email compromises, and I'll talk about those in the later part of this presentation. Laws against data interference, in other words, all those hackers that would go on the FBI website and they would actually compete as to who can deface the FBI website and how quick, right? So we have data interference, your denial of service attacks, system interference, right? What we call as ransomware these days. You know, when people come and they literally interfere with your entire system, your entire data, and they ask you for Bitcoin. I hope none of you has been a victim of same. Then we also have misuse of devices. Now, remember, this is 30 years ago. There were no tablets. There were no fancy cell phones. I remember my father's first cell phone was like a brick. It was like this big. Yeah, I remember, yes, it was like a big brick, like you could assault someone with that thing. You know? But the Council of Europe, they were mindful of the fact that the word device shouldn't just be limited to your hardware, but it can also be your software. So devices, as we know, are created to either do good or to do bad. So in this particular instance, anyone who uses a device to do bad, to hack, or to do any of the other crimes, that would also be regarded as a crime. Then we have, oh, by the way, I forgot to say, the first category of offenses, which I've just mentioned to you, Article 2, 3, and 4, and 5, those are what we call offenses against confidentiality, integrity, and availability of computer systems. Please just remember those words. They will come later on in the presentation. Then we have computer-related offenses, right? So the computer-related offenses are the BC offenses, not before Christ, but before the computer. Right? Before the computer. Before the computer, there was forgery. Before the computer, there was fraud. So they simply took these BC offenses and they put them into the digital context. So those are offenses against, what's that? Oh, sorry, offenses against computer-related offenses, yes. Number 3, then we have content-related offenses. Now, as you can see, there are quite a long list of content offenses, but the high mark basically there is child pornography, to be honest with you, right? Anyone who keeps child pornography, anyone who shares child pornography, anyone who procures child pornography, anyone who makes child pornography, and anyone who makes it available is guilty of an offense. Now, I remember some 10 years ago, I was actually doing training just for the legal aid. There was a video that was trending all over South Africa of a young girl in a very sexual, explicit manner, right? And then the frenzy started. People would get this clip, they would either look at it, or they would say, oh, how vile. But as vile as it is, they would forward it to someone, okay? So please, if you get vile material, just delete it. The moment you share the vile material, you are part of the vileness, okay? So that's very important. Then we also have infringement against copyright. This particular one didn't gain so much traction. We know we've got YouTube now, people put their music out there, people stream. The intention was to basically try and criminalize copyright copying. And we know from way back in the days when my dad still used to use an LP and go to a friend's place and then you had those cassettes. You remember those cassettes? Yeah? Right? And then you would go and you would record the whole LP. And then I remember myself as a young kid, on a Saturday, I'd be listening to the top 20. I'd be sitting there, just waiting for the song to play. And I'd be like, yes! And then you get the song you want, but, you know, a couple of seconds out, and then the guy says, yeah, Michael Jackson here. Oh, God, stop it. You know? So copyright has been an issue for years, and criminalizing it, they haven't done pretty well. Now, there's also ancillary liability. I'm not going to sit too long on that. Anyone who attempts is as guilty as the perpetrator, right? Basic criminal law. I remember Snyman, I did his course twice in varsity. Yeah, we all have our courses that we did twice. So the attempt is as good as the actual perpetrator. And then we have corporate liability. This is where now we say that corporates must stop being irresponsible or must stop making their platforms accessible to cyber criminals, right? You will see when we are dealing with South Africa, it's not in the Cyber Crimes Act per se, but if you look into the Criminal Procedure Act, there's actually a section there that deals with charging criminally a company. Obviously, there has to be a person behind that company as well. Then there's a whole lot of procedural law issues, and I'm not going to go into them word for word. For instance, the real-time collection of data by way of a court order. In other words, whilst the cybercrime is taking place, a court order is issued to monitor the real-time collection of traffic. Then you also have an interception order. When we get to South Africa, I'll be talking about the wife of the former Minister of Communications. That was very difficult at the time because I was actually advising the minister. And then in the afternoon, I'd teach about the minister's wife. But anyway, right? The case of State versus Twele. Don't know if you guys remember that one. Okay? An interception order was granted there. And then basically, like I said, I don't want to bore you with the Council of Europe because we're in Africa, so we need to talk about South Africa. But basically, there you have it. The Budapest Convention exists now for 24 years, all right? 24 years, people are still signing the Budapest Convention. We've signed it, we just haven't ratified it. And the reason why we haven't ratified it is because of geopolitics. That's the only reason, right? We should have ratified it by now. But, you know, the powers that be, they believe that, no, we shouldn't ratify this. And it is 24 years old, so why ratify something ancient like this? Then we have the ECT Act. Now, the ECT Act came in 2001. There's something very interesting about the ECT Act. Act 25 of 2001, and it came into law on the 2nd of August. That happens to be my mom's birthday. So I do not forget that one. It's not that I'm smart. It's just that 2nd of August is when the ECT Act came. Now, the ECT Act was an omnibus legislation. Do we all know what omnibus legislation is? In other words, it's a piece of legislation that deals with this and that and that and this. So there was e-commerce, there was a little bit of, what do you call this? Data protection was also in there, cryptography, domain names, and obviously the section dealing, I think it was chapter 10, the chapter dealing with cybercrime. Now, the ECT Act has been repealed by now. So why is Prof teaching us about old legislation? Because we have the theory against retrospective application of legislation, okay? So when we talk about the Cybercrimes Act, which came into being about 2 years ago, if there are any crimes that took place before the enactment of the Cybercrimes Act, then in terms of the theory against retrospectivity, you would have to fall back to the ECT Act, okay? And we know the long arm of the law. Some people get arrested 10 years, 15 years. So that is why I'm telling you about the ECT Act. But I'm not going to sit too long on it. It basically criminalized unlawful interception, unlawful access, unlawful interference, anyone who was providing or selling or designing a device. Remember the device as we had it there? And then also 86.4, which I don't think anyone was ever successfully prosecuted on, and that was the one where a copyright protected, you can actually see there the DVD. Can you see the DVD with the locks? So the law basically said, if you overcome the security protection of the copyright, then you are criminal. But we all know, when I was at Tux, we all had DVD rip. We all had all these copying tools. And yeah, I was one of the biggest infringers in my student years, okay? Just didn't have money, so it was okay. So, so in a nutshell, you then also have denial of service attacks, right? In other words, if someone made your system not functionable, whether partially functionable or not, they would be guilty of an offense. And then, I don't think I've got a slide for this, yes I don't. anyone who committed cyber fraud, cyber extortion, and cyber forgery, right? So those were the other crimes that existed. Just quickly, when we deal with electronic evidence, we go back into the ECT Act and we deal with Section 15, right? Section 15 is still the law, even today, right? It hasn't changed despite the Cyber Crimes Act coming in. And basically, the rule for Section 15 is bring the electronic evidence to court and then tell the court what is wrong with the evidence. That is the test of Section 15. So for any of you who believes that electronic evidence is not admissible, you have a big problem. Similarly had the council in the matter of Judge Mutata, right? The counsel for Judge Mutata, who is now a judge, we shall not mention his name, he actually went to court and he tried to argue that the video was inadmissible, right? And then Chief Magistrate Nair, yeah, the guy who did the Oscar thing, yeah, he then came and he said, look, this electronic evidence is admissible unless you can show me that someone has tampered with it, someone has edited it, but I'm allowing this evidence. So please, everyone must know, as much as electronic commerce is valid, electronic evidence is definitely valid. Then we have our RICA law. We know the Constitutional Court has been very busy in the last 2 years, first striking off certain provisions, and then Parliament failing once again. Are there any parliamentarians here? There are? Well, you failed. That's why it went back to court. The order said 24 months, right? And then that was not dealt with. So hence the Constitutional Court had to go and amend some things on RICA, put in safeguards, and all the things that they have done. I'm not going to sit too long on that. Then we have cybersecurity policies. We obviously have the National Cybersecurity Framework, which is also 15 years old. Then at some stage, the Cyber Crimes and Cybersecurity Bill in 2017 contained cybercrime and cybersecurity. And then some people like myself, we actually went to Parliament and we told the parliamentarians that, no guys, you can't have a Cyber Crimes Act and a Cybersecurity Act in one piece of legislation. They are not brothers and sisters. They are cousins, and they have a common ancestor called vulnerability, okay? And they bought into it. And then the cybersecurity part was removed, and then we had what we called, and I'm going to skip these, because I see time's not going to be great. Then we had what we called the Cyber Crimes Act. Now, the Cyber Crimes Act was signed into law in June 2021. However, it only commenced on the 1st of December 2021. If you have been unfortunate enough to be a student of mine, you will know that there is always the question when it comes to cybercriminality of retrospective application or not. That is why I told you earlier on against the theory of retrospectivity. So any cybercrime that happened before the 1st of December 2021, we still prosecute in terms of the ECT Act, and any crimes that came after that, we prosecute then in terms of the Cyber Crimes Act. The Cyber Crimes Act, a long piece of legislation, some call it great, some say it's not so great. I saw a recent article where I was being criticized for praising the act because I was part of the drafting process. Very interesting. But yeah, the Cyber Crimes Act, having these 5 parts, the substantive cyber crimes, malicious communication, then the attempt, and competent, verdicts, as well as aspects of sentencing. So, the Cyber Crimes Act dealing with unlawful access. We've dealt with unlawful access. The Cyber Crimes Act dealing also with anyone who overcomes security measures, that being a crime as well. Then we also have anyone who intentionally and unlawfully interferes with data or a computer program, your ransomware, those type of things. Section 6, anyone who interferes with data storage or storage medium or computer system. And then it gets very interesting. In Section 7, we have what we call aggravated offenses, right? So if you commit this offense against a court, for instance, now we have court online. So if you go and you hack court online, you will not be prosecuted in terms of the lesser offenses. You will definitely be prosecuted in terms of the aggravated offenses. Anyone who's done so to a financial institution, so if you hack a bank, you will also find yourself in those aggravated circumstances, or anyone who causes life-threatening situations. Then, there are our BC, our before the computer offenses again, cyber fraud, cyber forgery and uttering. We know what forgery and uttering is. So the forgery is when you create the forgery. Uttering is when you pass off the forgery as a real thing. And then we have cyber extortion, once again. Then, as I said, we have aggravated offenses where you are basically doing cyber crimes against an organ of state and other categories that are classified in there. I think it's section 13, has simply codified the crime of theft, okay? What I mean by codification is that theft is a common law offense, the intentional and unlawful appropriation of someone else's thing. And, so they've taken those words now literally and they've just created a section for online theft. So there's really nothing special about that. Then we have malicious communications. Now this one is very interesting because when the riots started, when our former state president was sent to jail, a whole lot of reporters were misinforming, and I hope the reporters and the journalists are here. They were misinforming the whole of South Africa that people were going to be prosecuted in terms of 14 and 15. And that couldn't be the case because the Cyber Crimes Act was not yet having been commenced, right? But now, if you incite violence now, or if you threaten someone's property now in the online space, then Section 14 and 15 definitely will kick in. Section 16, revenge porn. So when I teach this section, I first tell people that I don't condone people taking pictures of themselves in sexually compromising positions. That is an extremely private matter protected by the Constitution. Why would you want to take explicit pictures and videos of your partner? Especially if you're not married to that someone, because you don't know if in a couple of years that person doesn't love you anymore, and then you're going to trend. Because that's what people do these days. They make people trend, okay? So revenge porn basically is the section that says, look, if you take an explicit picture of someone else, God knows how you got it, lawfully, unlawfully, and you start sharing it, you are going to be guilty of a criminal offense. Moral of the story, keep the cell phones and the tablets out of the bedroom. Simple. Anyone who attempts, conspires, aids, induces, instigates, the legislature was quite busy there with those synonyms. Instructing, commanding, procures anyone to do a crime, they will be as guilty as the perpetrator of the crime. Then we have a thing called competent verdicts. Now, what is a competent verdict in this context? You get charged with Section 3, right? Unlawful interference or unlawful access. However, it is one of those which is an aggravated offense. Then the court on its own accord can actually find you guilty of the aggravated offense, not just of the offense that you were initially charged with, right? Because it's a competent verdict. So there is some flexibility now that the courts have. And when it comes to sentencing, I used to say in terms of the ECT Act that cybercrime pays. And people would be like, huh? What do you mean? I said, cybercrime pays in South Africa. Maximum 5 years. Maximum, I think the fine at the time was 50,000. Sure. So you do a heist of 25 million, you sit in jail for 2 years, and off you go into the sunset, right? That's how the Cybercrimes Act used to be. But now, the legislature has come in and said, no. This cybercrime thing is a problem. We are going to start nailing people from 5 years, and depending on the nature of the offense, 10 years, 15 years, and if the magistrate believes, or the judge believes, and he has that penal jurisdiction, that what you have done is just very bad, then he or she may actually find you guilty and actually sentence you for a longer period as well. So there are definitely tougher sentences now in the new Cybercrimes Act. Now, Section 20 is this protection order, which I just don't understand. So Section 20, although it is not yet in motion, because there are no rules for it, the Rules Board is probably busy with that. Section 20 is a section where you can get a protection order, but it's quite silly, actually. So the person shares your revenge porn, right? And then you charge him with revenge porn. And to make sure that he doesn't further disseminate, you go and get a protection order. I don't know, right? But that is how it's been structured, to say, to stop you from doing repeat malicious communications, repeat revenge porn, the court can actually order you to stop whilst the criminal investigation and the criminal procedure is taking place. Right. The Cybercrimes Act has given our police various powers to investigate, search, access, and seize articles. I'm not going to go into all of that. How's my time, by the way? 5 minutes? Okay, right. And then there's also these sections that deal with disclosure of traffic data and also interception orders, but most of these sections are not yet active yet. And then Chapter 6 talks about the SAPS having a designated point of contact. If you have seen the designated point of contact, please let me know, because I haven't seen it, right? My commercial clients and even my normal clients still have to come to me to draft them an affidavit so that they can go to the police station, because when they go to the police station, and with respect to the police services, they have no clue about the Cybercrimes Act, right? So that is one of the critiques, I guess, about our act and the fact that capacity hasn't been built around this act. There's a section dealing with evidence. It does not repeal Section 15. Remember when I was talking about Section 15? Bring the evidence to court, let the court decide about the value of this evidence. This particular section talks about affidavits of experts in computer science, experts who are computer programmers, so that you don't necessarily have to always have people coming and testifying to these, right? So they can actually do so by way of affidavit, and this section basically sets out how you must do so. Then, last but not least, there are two cases that I'm going to talk about. Howardine versus Edward Nathan and Sonnenbergs. Any colleagues from ENS here? No colleagues from ENS? Okay. So what happened in this one was ENS were basically the conveyancers in a matter, and an elderly lady was communicating with the conveyancers, and at some point there was what we call a BEC, Business Email Compromise. Someone hacked her email on her end. They went to court, and in the court quo, Edward Nathan was held to be negligent because they did not put in enough care and safeguards to protect the elderly lady from cyber criminality. This matter has luckily been overturned by the Supreme Court of Appeal, and the Supreme Court of Appeal says no. You need to check the banking details of the person that you pay. He who pays has a positive duty to ensure that where he's paying the money to is the correct place. So there's nothing wrong with phoning, checking the banking details. There's nothing wrong with asking for a bank letter, even although they intercept those as well. We've heard those as well. But basically put in practices into your practice to ensure that business email compromises don't affect you. Then we have the case of Gerba versus PSG. I think this one was Judge Fisher, where she decided contrary to what the Supreme Court of Appeal said, and PSG Wealth were held also liable, having not put in a duty of care, and once again, monies were lost in that one. And that's it, folks. As I said, I didn't intend to teach, but that's the presentation for the day. Thank you very much.
Thank you so very much for that presentation. Prof, do have a seat so we can have a conversation on this. Thank you so much for those comprehensive presentations, quite informative, I must say, as well. Do we have some participation on the floor following those presentations? But maybe also to get things started, Prof, let's just hear from you. I mean, the Cybercrimes Act has been criticized, for being all bark and no teeth. Just what specific enforcement gaps or institutional weaknesses are preventing it from having real impact, and how can all of these be addressed?
I think the issues are on three levels. I think we, as the possible victims of cybercrime, we are the first problem because we are not vigilant. We share our information recklessly. When people give us an app, we are very quick to install an app on our phone, whether you need it or you don't need it. Yeah. Have a look at your phones right now. Half of the apps on your phones you're probably not using. Yeah. And you don't know what they're doing with your data. Might be going to Ireland, might be going to China. If you've got TikTok, your data's in China. If you're using Google, your data's in Ireland. Just saying, just warning everyone, okay? If you're using Facebook, your data is in Silicon Valley, okay? So, first of all, as I said, the first level is us. We are the first problem. The second problem is education. We need to educate kids at creche. We need to educate children at schools, high schools, all the way to varsity. In fact, if you are a university student in 2025 and you don't know how to use a computer or how to conduct yourself in the online space, you might as well not be in a university, right? So I think education is the most important one, and not just education to the young people, education to the elderly people, right? They are mostly the victims of cybercrime.
Yeah.
And they're keen. I've seen my mom sometimes on her gadget, She goes off. And I mean, I would remember even my late father would sit there on his tablet and he'd be pressing. I'd be like, Dad, don't kill the thing,
Yeah. Yeah.
So the elderly people, I think they also need to be educated. And then last but not least, our government needs to have police officers that are properly trained to take on these cases, to prosecute these cases. I'm not saying that the entire SAPS is incompetent. I'd be lying if I do that. There are some great colleagues of mine in the SAPS who are doing some beautiful work, but they're just a handful. Some of them are in Durban, some of them are in Joburg. What happens if someone does a cybercrime in Messina or somewhere in the remote villages of the Eastern Cape? You know, that is where some of these crimes take place, and I think that is the issue. Capacity building within our police services.
And I wish to piggyback off the point that the Prof has made also, so you can also weigh in, Prof, on just how do you think we were actually ready for this digital wave? Because technology has turned us into one big global village. Do you get a sense that we were ready as a country, or this is an era that caught us off guard in a way?
Yeah, I mean, sometimes it's better not to be first out there and actually to learn from others' experiences. I think we've got left behind in a few respects, also with our labor law and the development of an innovation around types of agreements. I think we might be a little bit resistant, conservative, for various reasons. Yeah, but we do have enough adopters, I think, to make it viable. But yeah, some way to go, I guess. I mean, yeah, I do worry that there's a lot of garbage, you know, and you know, to have the ability to filter and to work out what is of value, and you know, yeah. So I think education is huge, and I don't know whether we're addressing that in a way that's having any impact. I think we're being reactive rather than proactive.
Yeah.
You know, we do have a presidential commission on the 4IR. I'm not sure, yeah, how they've rolled out. Yeah, I don't know. Yeah,
Maybe
I think capacity and resources are a bit constrained, but on the other hand, sometimes you can overdo it, and I think we're fairly good at being reactive. I don't know.
I think Prof. Cordiers is correct. I think if there's one thing that we do superbly in this country is to write policy documents.
Yeah.
One policy document after the next, and then after 5 years, when there are new politicians, we draft a new policy document, then we have a planning document, and then we do this, but we don't get there, you know?
Yeah. What happens to the implementation part?
With the implementation part.
Yeah.
And I think that is one of the things that is causing us to lag behind. Technology is not waiting for us. Technology is like time. Your IoTs, your Internet of Things, your artificial intelligence, as you've mentioned, aspects relating to cybersecurity itself, they are developing and changing every day.
All right, let's open it up to the floor. Sure, go ahead. Good afternoon.
Thank you so much, and I want to appreciate the presentation. I think my interest is around the malicious communication. And for me, is to say, as the bill was actually enacted and actually signed in 2021, I think it's just a recent thing. My concern and question is, how do we then ensure that whilst we actually put the act into effect, how do we educate and advocate? I think it is the majority of us in this room that actually start to know about this act. And you can think of the millions of people that are out there that are not aware of this. And I can guess the issue of malicious communication takes place because people, it's not out of ignorance, it is lack of knowledge about these measures that are put in place. So I've seen that you are with the University of Nelson Mandela. My concern and also a comment would be, how do we integrate? Because over the years we have been talking about communication techniques, communication strategies. How do we start to integrate the aspect of malicious communications in terms of the issues around cybercrime as part, one, of the initial teacher education programs in our universities, two, as part of strengthening our curriculum, because communication is taught across subjects in school. because it's not all kids. I think the students that we have is because it's post-schooling. Those that will not have an opportunity to go to universities, they will never be able to know about this. How do we start it? Either through the life orientation as part of life skills and life skills knowledge, so that we integrate this information and make it accessible to the young generation that is coming, which actually are going to be impacted by this, because I believe prevention is better than curing or actually having to see a number of cases whereby people will be charged on this. Thank you.
Thank you so much. There's another question on this side, and also just to bear in mind, maybe Prof, I actually marvel to see some workplaces adapting to this change and also being part of the change that we see insofar as technology is concerned. I remember there was a conversation I had around some workplace which did some sort of a simulation on sending its employees some sort of an email to see if they would actually click on the link. Funny enough, most of the employees clicked on that link, which opens them up to phishing. So let's continue with, yes, sir. Good afternoon.
Good afternoon. Good afternoon, my colleagues. My name is Aiden. I'm a full-time substitute in the Western Cape. I just want to know, and because this is an issue that we have been dealing the whole time, with teachers calling me, with regards to the cameras inside the classrooms, with regards to the Popeye Act, what is the law saying with regards to allowing cameras in the classroom? Thank you.
All right, do we have more participation from the floor? Yes, right at the back, please. Okay, you can start there though, it's fine.
Good afternoon. I am Nwabisa from Port Elizabeth. My question is, how would the department, that is the employer, deal with revenge porn sent by educators or fellow educators, learners, and also failure by the principal or educators who are aware of videos being sent but fail to report? Example, the recent case in the Western Cape where the educator sent an explicit video of a learner. To a learner.
Sure.
Thanks.
Thank you so much. Let's get the last question, please, just so we can round everything up. DG will get to you as well.
Sure.
Okay.
Yeah, thank you.
All right, you first, sir. Go ahead. Good afternoon.
Thanks. Good afternoon. Quick one is funding cyber security measures. Does our state have provisions for financing this against the various competing needs in the budget and so on? I say this coming from the college sector where there are many challenges in colleges in terms of management and governance, competing priorities and resources, and lack of resources. Now, when you try to fund initiatives of this nature, there are absence of resources. Now, what, in your analysis, Doc, Prof, does the state has avenues of really financing cyber security measures by education institutions? Thanks.
Thank you so much. Yes, sir, you can go ahead.
No, mine is just a very simple request that I believe we are a handful of guys who are experts in this cybercrime thing, but also on policies on this, in particular for various workplaces. Is there a way by which you can initiate collaborative approaches with various departments so that in their policies they are also captured this? Because I can imagine that the public sector maybe currently is the most targeted, in particular by these cyber criminals. But obviously it is through people like yourselves that possibly the situation could be saved or at least mitigated. This is what I want to check from you, Mfana Kamtuze.
Thank you very much. Last but not least, DG, go ahead. Can we get a microphone? All right.
Thank you very much, Chair, for the privilege. I must commend the two presenters for enlightening us, but also commend the organizers of this seminar. It's been extremely invaluable in many ways.
Yeah.
I left for a few minutes and I felt that I lost a lot. So I must confess. You know, cybercrime is a problem. And our children are going to fall prey to things that do not overtly appear as crime. And I think I'll be the first one to request for a note on your presentation to go and first give to my 3 children because they are very active in the social media space, in the technology space, and our children are totally oblivious of these crimes. Number 2, if our schools, children of the nation, really need to be brought on board about these crimes. Because if we are not going to do that, we are going to fill our presence with many of our children. They are more active on these things than we are. And the second group, of course, is employees. That we also need, I think, apart from just a policy perspective, just the level of awareness.
Yes.
It's crucial that people get to understand, you know, the dangers with social media. The last point that I want to make is to you, Prof, about what you call humanizing, you know, technology and humanizing the work. More often than not, people talk more about the adverse effects of artificial intelligence. But I think we need to balance. Artificial intelligence also bring with it opportunities, new jobs, new skills that we need to look at. We need to retrain the current workforce to make sure that it's alive to opportunities that are coming. And to me, artificial intelligence is a tool in the hands, it's a product of human intelligence. And it cannot replace human intelligence. And that battle we must settle. Nobody must think that, of course, routine work, there are instances where, you know, artificial intelligence can replace, you know, human activity. But nobody must think that the next revolution is going to be brought about by artificial intelligence, as some people tend to believe. Thank you very much.
Thank you very much, DG. Professors, let's wind it up then with your responses. Perhaps you can go first.
Yeah, thank you. So, I mean, just Aidan's point about cameras in the classroom and, you know, the experiences that students have. I mean, I do think a lot of this is about policy and having very clear guidelines. You will have a different perspective from a cybercrime, but I really do think that that policy space needs to be developed in terms of both employees and children. That education, but also the contractual relationship we have with children and their parents at school and at university. So your ICT, your use, your policy use. But I thought that example of, you know, having a simulation and most people open it up anyway is quite scary. And you know, what are the potential, it can have potential consequences. So I think there's a lot of work to be done in that policy and education space. Just on the last point there, DG, yeah, I mean, I think it is about finding the balance, and often we catastrophize technology. We either catastrophize it or we think it's going to solve all our problems, and we just have to find that balance and find what works and what doesn't. And we cannot, you know, I mean, at university, for example, I had colleagues who took the position that they were not going to use it, their students were not going to. It's not realistic because they are going to use it and you are going to have to deal with it and you are going to have to adapt. So I think there are a lot of benefits and augmentation for work. But but the more skilled and, the more education we've had and training around that, the better we will make use of those opportunities and avoid those pitfalls. Thanks.
Prof?
Thanks. I must say that the Department of Basic Education has actually started an initiative with Google where they are now introducing the whole issue of cyber law into their basic curriculum. So for a change, we can actually clap hands for what our government is doing in that respect. Yeah, where they're doing well, we must clap. Where they're not doing well, we leave it. When it comes to the question of learners and teachers sharing, content that's not great, I think the problem is bigger than just, explicit content. I think the whole interaction between teachers and learners, I think that relationship needs to be looked at first. Why is a teacher having a learner's cell phone number in the first place? Right? Doesn't make sense. Right?
Don't they, though, nowadays to communicate on WhatsApp on school?
No. What learners are doing now is they go in teams. My kids, for instance, they use tablets at their school. At CBC, they use Teams. It's nicely ring-fenced. And, they're not doing WhatsApp. So I think it's very, very important to first look at, the relationships between teachers and their pupils. And I think we should also generally teach our kids at home, What do we do when our kids have birthdays? We slap them with an iPhone. Shut up, here's the iPhone, But you don't know half of the things that the child is doing with the iPhone, right? The internet is as dangerous as being in downtown Johannesburg in the afternoon. No, I'm being serious. That is how dangerous, if not more dangerous, than being in downtown Johannesburg. So that was the question on malicious communications, tried to cover the education question, the papaya question. I was hoping papaya would not come. That was in my past life at the regulator. But with that having been said, the papaya is very, very clear when it comes to processing of information. It does not prohibit the processing of information, but it ensures that information is processed lawfully, reasonably, and with consent. So if you sign up your child and you look at the contract, which most probability you will not do because you just want your child in that school, there may be a consent clause in there to say that we actually have cameras in our school, right? Yes, it becomes contentious once you start putting cameras in toilets and other places. That is just not appropriate. But I think processing of information via short-circuit television is a reality. The whole issue there is about reasonableness and consent and also doing it in a lawful manner. So that's that question. And then the gentleman at the back.
Funding.
Oh, funding. Oh, yes, funding for cybersecurity. I think our country has lagged a little bit behind with funding for cybersecurity. And I don't blame our country. We've got bigger problems than cybersecurity,
Right.
As much as cybersecurity is a problem for the government, I think the private sector is the one that needs to step up. Yes, we have government certs, the Department of Communications, in conjunction with the State Security Agency and the JCPS cluster. That's all great. But our private sector really, really needs to step up in terms of spending more money on cybersecurity, making cybersecurity part and parcel of your budget. Me as an attorney, part and parcel of my budget is that I need to do my audit the next 2 weeks, right? I need to file my audit. I must pay an auditor. And these are things that must just happen. Are you with me? And then lastly, in terms of getting cyber law out there, yes, for higher education institutions. Some 10 years ago, the late Nick Swart, he was the director at the Law Society of South Africa. He approached myself and Prof. Tana Pistorius, and he said, you two guys need to do a course for us on cyber law.
Yeah.
So yes, the legal profession really caught up. Every second to 2-3 years, I have to update slides, I have to update content. The legal profession is definitely not behind. And at that time, the LLB was also being revised, I remember. And cyber law came in as one of the subjects that ought to be in the curriculum. But in my view, and in my respectful view, if you are a law student, you should have cyber law in the first year. Not in the fourth year, in the first year. Because everything now happens on cyber. Our phones,
fingertips.
our lectures.
Our fingertips, yeah.
Our fingertips.
Thank you so much, Professor Sizwe Gamtuze. Thank you so much for popping in. Thank you very much. And Professor Collier from the University of the Western Cape, thank you so very much. Okay, ladies and gentlemen, so this now concludes today's session. Good news, we're not coming back after lunch. You can go and relax. We will see you again bright and early tomorrow for the third and final day of the seminar. Do have a spectacular afternoon going forward. Take care.
South Africa's labor terrain is shifting faster, deeper, and more complex than ever before. And when the landscape changes, leaders must rise. Join us from the 11th to 13th of August 2025 at Empress Palace in Johannesburg for the Education Labor Relations Council Labor Law Seminar, under the theme, Adapting to an Evolving Labor Landscape to Promote Social Justice. It's a strategic gathering of policymakers, union leaders, educators, and legal experts converge to chart the future of work, rights, and equity. Education Labor Relations Council Labor Law Seminar 2025, where transformation begins. When labor evolves, justice must lead.